Very good evening, one and all present here. Welcome to today's CCP meeting on Labour Laws 360 degree of Compliance and Accounting. May I now request SIRC Vice Chairperson CA Revadi Raghunathan to escort today's speakers Mr. Srinageshwar and CA Mahesh Krishnan sir to the dais, please.
Most welcome. Thank you.
We will start today's proceedings with the invocation of ICA motto song. Let us all rise for ICA motto as a mark of respect to our mother and state.
Yaeshasupteshu jagrati Yaeshasupteshu jagrati Kamam 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 kamamsho Pursho nirvimanaha Tadev shukram Tadbrahma Tadevamritamuchyate Tasmin lokaha Sarve tadunatyavikaścana Etadvaita 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 Etadvaita.
Thank you. Please be seated. May I now request SIRC Vice Chairperson CA Revadi Raghunathan to deliver a welcome address.
Good evening, everyone. Very warm welcome to Srinageshwar sir and Mahesh Krishnan, CA Mahesh Krishnan, for today's meeting on Labour Laws 360 degree of compliance and accounting. Actually, a lot of thought went into this, topic, zeroing in on this topic, and also how we structured it. And Mahesh and I had a lot of discussions about who would be the right person to invite, and getting sir's time was also a little difficult for us. We are all very fortunate that Nageshwar sir has actually agreed to come and address us today. He is holding such a senior position in the Simpson Group as the Group HR Head, Senior Vice President in Simpson Group, and he's come here today to share with us his experience, and he's going to give us a practical knowledge, whatever his experience is. While Mahesh, if he finds it necessary, will touch upon the accounting and audit aspects of it, the compliance, other matters will be dealt with by sir. And we are all very fortunate that you agreed to share your knowledge with us, sir. And see, at SIRC, what we are trying to do is to give innovative topics which are going to be helpful for us in our day-to-day practice, and we're inviting experts who are, not chartered accountants also to share their experience with us, because we don't want to have a one-sided view of transactions. We need to have, like we said, a 360 degree of knowledge of transactions, and when we go for an audit, we need to view all transactions with this 360 degree view. And labor laws is something which is very important, we all know, and the government is also going to view it very strongly if we are not going to comply with any of the labor laws. And whether the company is going concern or not a going concern, or whether it is in insolvency, labor laws is something which we all need to comply with. And in fact, whatever is due to the employees is outside the liquidation estate itself. We have to keep it outside the liquidation estate and ensure that the money reaches the employees. So when that is the importance which is placed, we need to have a view of how an expert who's not an accounting professional is dealing with the issues on a day-to-day basis, because tomorrow when we go for audit, we also will know what is it that we need to look at. So thank you very much, sir, and I would request you all to actually tell all your colleagues also, to come and attend these programs. We have a lot of registrations for this program, but due to various reasons, many people are not able to attend on time. We say 5 o'clock and we wait for people to come, and we start at 5:30. Some people who make it on time are put to difficulty because they come, they maintain the time, but we wait for people who are not able to make it on time. So we request that people also come in on time. If it is 5 o'clock, we would like to start at 5 o'clock because the speakers are here and some of the members are also here. So thank you very much, sir, again for accepting this. Thank you very much, Mahesh, for introducing us to sir and convincing him to come here and share his knowledge and experience with us. Welcome again. Thank you.
Requesting Revati madam to introduce both the speakers.
Yeah, I will start off with Srinageshwar sir. Like I told you, he is at present the Senior Vice President Group Industrial Relations of the Simpson Group of Companies, which is a part of the illustrious Amalgamations Group. He started his career with the Steel Authority of India Limited and thereafter moved to the textile industry and subsequently to the automotive industry. He has a PG degree in Labour Management and a postgraduate diploma in Social Work and Labour Welfare from the Indian Institute of Social Welfare and Business Management and LLB, both from Calcutta University. He also holds the postgraduate certificate in personal practice from the British Institute of Personnel Management, United Kingdom. After 3 months of intensive training course with the International Society, UK and British Institute of Personnel Management. Sir, we didn't know that there were so many degrees for HR thing. Mr. Nageshwar has been trained widely in India and abroad, and he's also been trained as a trainer. He has been active in many employer bodies like the Employers Federation of Southern India, All India Manufacturers Organization, All India Organization of Employers, Federation of Indian Commerce, Federation of Indian Chamber and Industry, and Confederation of the Indian Industry. He's got so many achievements. He has been active in, he was the chairman of the Tamil Nadu Committee of the Employees Federation of Southern India for 2 terms, and also the chairman of the Tamil Nadu branch of the All India Manufacturers Organization. He is a member of the Executive Committee of the All India Organization of Employers and has been a member of the CII National Committee on Industrial Relations. He represented the employers' interest in the discussion held at the Ministry of Labour and Employment, Government of India on the recent labour codes for the last few years. He has been representing the Council of Indian Employers in the Indian Labour Conference held from 2007 onwards. He's represented employers and was he's been representing employers and was part of the employers delegation at the ILO conference at Geneva in 2008 and 2010. He was one of the employer representatives representing India at the recently held Asia Pacific Regional Meeting of ILO at Singapore, where he was a member of the drafting committee of the meeting resolution. He represented employers group in the negotiating out of the crisis forum on social dialogue and industrial relations in the midst of economic crisis in Europe at Turin, Italy in 2009. Represented the Indian employers group in the bipartite meeting held with the Japanese employers group NICC in Tokyo. He was a member of the state government committees including Working Group on Labour for the State Planning Commission, the Good Industrial Relations Award Committee and the Labour Welfare Board, Minimum Wages Committee of the Tamil Nadu State Labour Department representing the employers. He was a member of the Board of ESI Corporation of India and the National Social Security Board representing the Council of Indian Employers. And currently he is the member in the Board of Workers Education formed by the Government of India. Sir, it's a very small profile, I should say, with all the experience that you have. Thank you so much once again for accepting to come here and talk to us. I didn't know there were so many organizations for the labour welfare in the country. We see only the PF and the ESI. We don't see so many other organizations which are working for industrial relations. So that's why I didn't leave you in one single of your achievements here. I'll move on to Mahesh Krishnan. He's a partner in RG Enterprise. Everyone will know about him. He specializes in providing assurance services and gap convergence services for companies spanning across various industries, and he has almost 3 decades of experience in assurance and attest functions. He has experience in extensive statutory audits spanning across a sector of industries including automotive and its ancillaries, IT, IES, industrial markets, consumer markets, etc., covering listed companies, large MNCs and large public companies, as also small to medium companies. He's a grad CWA in SEMA UK, past finalist, and has also completed the DISA and post-qualification course on valuation given by ICAI. He has actively participated in many training programs on bank audits, accounting standards and auditing standards at various platforms of ICAI, and he has been a part of the subgroups of the Institute of Chartered Accountants in the preparation of guidance notes and accounting standards evolvement. He's been a joint secretary of the Society of Auditors Chennai for the past 7 years and is a special invitee of the Accounting Standards Board of ICAI and also a technical reviewer of the QRB and the FRRB. A very simple profile, but still waters run very deep. So presenting to you both the speakers today, we are waiting to eagerly hear you, sir.
Yeah, before I hand over the podium to the speakers, I may now request Revati Madam to honor our Srinageshwar sir with a Kanchipuram Silk shawl, a health bouquet and a memento on behalf of SIRC of SIRC. Also requesting Madam to honor our second speaker, Mahesh Krishnan sir also with a memento and health bouquet. Over to Srinageshwar sir.
Good evening. Thank you, Madam. Thank you, Mahesh. And I'm here in front of you. Giving a subject like this and asking me to talk is to put the entire universe into a bottle. I was wondering as to how and why and how I should be talking about this subject to a group of auditors and give them that knowledge with which they will beat me around later. Well, anyway, that's said in a lighter way. But I used to wonder, in fact, even this afternoon, I was asking one of our auditors, internal auditors, as to what normally an auditor will be looking for in a professional like me. He was telling me something, but nevertheless, that did not give me much of clue as to what and how I should reach your heart and mind. But then, in such circumstances, you normally draw your own pattern and start getting into the talk. So, right from the beginning, this is a question that has been plaguing me quite a bit as to how I should structure this for you. This is my second brush with auditors as far as the stage is concerned, because about in 2012 I had talked to the Society of Auditors somewhere in Luz, and that was quite a nice meeting with them. So it's not that I'm quite unfamiliar with you, I'm fairly familiar, but only the point is that when you are changed, and perhaps the type of people whom we have seen at that time now is maybe different. Anyway, be that as it may. I was thinking as to what will be your expectation. I made certain assumptions. I'm not going to talk about the compliance part of it, because the compliance normally comes at the end of any act and law. What are the reports, what are the returns, how it is to be filed, when it is to be filed, and what will be the penalty, and so on and so forth. That you can always get it just by opening the concerned act and flip through and come to the last chapter, chapter 10 or 11 or 12, and arrive at that. And if you start reading it, it will only read like a very a mash of problems, and which will be a nightmare for any employer, like imprisonment, fine, so on and so forth. Well, but nevertheless, instead of going into that, I thought I should take you through the presentation with every act. I have lined up about 11 acts here. I really do not know whether I will be able to do that much of justification. So pardon me if I rush through, but nevertheless I would use my own discretion to determine that this is the point that the auditor might know, might be interested, and then perhaps explain a little more in detail with cases and things like that. So if with your permission I'll start, and before that I'll give you one chance as to which act you would like me to talk more, or which act you would not like to talk about at all. That's something I want to know. Is it possible for you to throw some light, even one or two will be all right for me, because I take that opinion as a representative opinion. Pardon? Retrainment, okay, I have provided for it, okay. Then, sir?
What are the total 11 acts?
That's that the experience speaker, the grey hair speaker. Okay, see, it is taken from Factories Act, Payment of Wages Act, Minimum Wages Act, Payment of Bonds, all those monetary acts, mostly. Okay, then followed by Employees Provident Fund Act, ESI Act, Industrial Disputes Act, Conferment of Permanent Status of Man Act, Contract Labour Act, National and Festival Holidays Act, and so on and so forth. You know, in our country, there is no dearth for acts. Even today, I came across one law called the Captive Elephant Transfer Act. Can you ever understand that there is an act which governs the transfer of the captive elephants from one place to another, how it is to be transferred? There is an act, 2024 enacted. So there is no dearth for acts in our midst here in our country. The only difference between other country and our country is many other countries do not have many acts, but they follow it. We have so many acts, we don't follow it. Well, it is not recorded, I suppose. Anyway. But the point is, if you look at the laws and rules concerning the labor, I would conservatively estimate is about 5,000 in our country, 5,000. Out of that, many of them may be a little different, but nevertheless, I'm talking about the laws and rules. You know, the rules are made under the prescription from the Act. So, with all this, we get confused, and therefore, this central government has decided to bring the codes into 4 codes, combining about 44 central laws. But nevertheless, most of the codes are, if I may call it, pari materia with the existing law. So therefore, many of these, like you have 2013 Companies Act and 1956 Companies Act, and many other provisions are copy and paste. So in the same way, we also have it here, but with some changes here and there, which will become useful for both the employer as well as the employees. I've been quite actively involved in the formulation of this, or rather in the discussion on forming these codes in the central ministry. I have attended almost many of the meetings on behalf of the employers, thanks to those organizations which had faith in me, and I was one of the persons. So I've seen it how closely, I've seen it in a very close quarter as to how these codes have been made. Many of them are copy and paste. So, well, that is the case, and labor law is like criminal law, in the sense many of the practices have to be governed by the laid down laws, as you know, laid down laws, court enacted ratios of laws. So it becomes more complicated. It's not enough that you know the law, you also need to know, in order to be a successful IR professional, or even for that matter HR professional. You got to know that, you got to know that. Of late, even the technological companies and the other companies have become more aware of the existence of industrialization and the labor-related matters when the problems come in the technological companies and with the formation of unions like Fight, Right, and so on and so forth. Well, so now let me get into this thing. So these are the laws that I intended to talk about. Any preference, sir? Okay.
Factories Act and
Okay. So okay, we open it. So we know why we require the labor laws. Labor laws are basically required for protecting the employees' rights as well as to know to ensure the labor welfare, and also to give us a direction as to how to go about it. And straight away, these are all flowing out of our constitution. The constitutional provisions of labor legislation are given in both in the fundamental right as well as the directive principles, and labor has been placed in the third list, that is the concurrent list, where both the central and the state governments can enact amendments and enactments. So that complicates certain things more, which the central government has tried to correct it this time. They have, if I may call it, usurped many of the powers of the state government into them to see that they are in a position to enact many of the laws and rules exclusively reserved for their thing, by inserting a simple clause that the appropriate government for such an act will be the central government. So there ends the matter. So the central state government cannot get into that in enacting any rule or law simultaneously, though it is under the concurrent list. We can broadly classify the labor laws for those uninitiated, if I may introduce it like this. One is the industrial relation legislation, like Industrial Disputes Act, Industrial Employment Standing Orders Act. Industrial Disputes Act is for the dispute resolution. Industrial Employment Standing Orders Act is to prescribe service condition for the labor. Trade Unions Act is governing the formation and carrying on the business of the trade unions. That's one of the oldest Act, 1926. So this, the first union was formed, as some of you may be knowing, it was formed in Madras Labor Union. And also simultaneously we had the Ahmedabad Labor Union, which was taking care of the labor rights and in the textile companies. That's where Mahatma Gandhi started his stint to protect their rights. It is only out of the Ahmedabad cases, the labor appellate tribunal cases, that slowly the bonus law also evolved over a period of time from there. Anyway, then the second one, we say that wages legislation, you have Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. This Equal Remuneration Act is to prescribe a law bringing parity of salary and wages and benefits between the men and women. Many times you will be misled by somebody to say Equal Remuneration Act means it is one work, one wage, same work, same wage. No, it is nothing to do with this. Even the very seasoned trade unions, you used to say sir, it is Equal Remuneration Act, sir, you put sir, there is nothing like that. It is a totally gender-based one. They said that both of them should be paid the same. So it is equal remuneration. This Equal Remuneration Act in the newly formed Code on Wages has been reduced to only 3 lines. The entire law has been reduced to some 3 or 4 lines in the new code. So therefore, it is a wages legislations are there. And the first 4, the second 4, Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, Equal Remuneration Act, they have been formed into one code today called Code on Wages 2019. Okay. Then you have Social Security legislation. We have Employees ESI, EPF Act, Employees Compensation Act, which was earlier called as Workman Compensation Act, making a kind of a very wrong impression of the people that is meant only for the workmen. In fact, many people did not know even for a long time that this Workman Compensation Act did not cover the clerical cadre of your office. Clerical cadre. It was not covering. But by an amendment, the central government brought as they covered this clerical cadre also. So that nomenclature was removed and was brought as the Employee Compensation Act. Then you have the Maternity Benefit Act and the Payment of Gratuity Act. And these are the acts which you normally deal with in any place. Then we have welfare and regulatory legislations, a plethora of law. Notably, you can see Contract Labour Regulation Abolition Act, Child Labour Abolition Act, Regulation, Prohibition Regulation, Factories Act, the Interstate Migrant Workmen Act. Whenever you go to any hotel, you will find the Assami, all those people, they are all covered by Interstate Migrant Workmen Act. Motor transport workers, plantation labour, sales promotion employees, like that keeps going out. And National Industrial Establishment, National and Festival Holidays Act. Actually, it is to be called National, there is a mistake from my side, I should have added something more there. It is a National Festival Holiday and Special Holidays Act, thanks to Mr. O. Pannirselvam. We will come to that later. Okay. And Tamil Nadu Manual Worker Scale, Tamil Nadu Payment of Subsistence Allowance Scale Act and Shop and Establishment Act. So these are the acts on the welfare and regulatory legislation. Now I will come to the Factories Act straight away. As you know, factory is a place, a wider definition has been given for factory. Even if you have a godown where you have used power to do the packing, it's also considered as a factory. It's not only a manufacturing area, don't get under the wrong impression. So where you have, if you have 10 workers, not workmen, workers, with power and 20 without power. See here, whom does it cover? It covers everybody. It covers managerial people, except for the managing director, who is considered as an occupier of the factory. Who is the occupier of the factory? Occupier of the factory is the person who has got ultimate control over the affairs of the factory. So except for him, everybody is covered by, though they use the word worker. The worker includes me, him, everybody. So therefore, let's not think there is any delimitation there. Not like it. I don't know if I am audible to you.
Yes.
Am I audible to you, Sri?
Yes,
Okay.
Please come.
So, is everybody is covered. Everybody is covered. Now, in factory, how the from the time it is registered, the one most important thing in any factory is the factory registration. Factory registration. The factory is to be registered in an appropriate manner with the Inspector of Factories, whom now it's called Director of Industrial Health and Safety, DISH we call it. And these are the people who give you the registration of the certificate for the factory. The second thing is, okay, thank you. Yeah, okay. So the Factories Act covers the safety, health and welfare of the workers. And I have talked about the occupier. The one more person who is more important in the factory is you have got a manager of the factory. Am I audible? No, it's okay. I'll sit after some time.
Okay.
After I get tired.
Okay.
There is an occupier of the factory and there is a manager of the factory. The manager of the factory is the person who is interested with the management of the factory. These two people become totally responsible for conducting the affairs of the factory or for any violation of law in the factory. These two become responsible. There is a separate section called, there is a 7A, which talks about the responsibility of the occupier. It talks about the responsibility of the occupier. So it's a third person, third actor who comes in picture, who is very important, is the safety officer. The safety officer. The safety officer is to be recruited only through the employment, through the public advertisement. You cannot, I like Mr. Mahesh, so he becomes, so he is to hold a certain qualification, which is to be recognized by the inspector of factories, and he should have certain experience, and only then he can become the safety officer. And if there are going to be more than 1,000 people, there have to be more than one safety officer. So, from the auditing point of view, you need to look at who is the occupier, who is the manager, and all that. Why it is very important is for the purpose of pinpointing the responsibility for any violation. These two people will get the show cause notice. They get prosecuted, and either with fine or with imprisonment, and sometimes with both. Sometimes with both. That's one thing that we need to look at it. I will come to that later. And the safety officer also, like safety officer, you have got a welfare officer. The safety and welfare officers, they enjoy certain immunity from discharge and dismissal, because before they are discharged or dismissed, you have to obtain the permission from the DISH, that is from the Chief Inspector of Factories. So, therefore certain statutory protection is given to these people, safety officer and the welfare officer. But that is not the case with the occupier and the manager, because they are liable for prosecution. There is a safety committee which is there with the 250 workers, and if it is a hazardous process or any hazardous substance is employed, am I not audible?
Audible.
Okay, then they have to form a safety committee with representatives from both. When you go, say, for auditing, it just strikes to me, you need to know whether that particular factory is employing any hazardous process or any hazardous substances, using hazardous substances. Because the way that Factories Act looks at hazardous substance and hazardous process is different from the normal factory. Now, what is this hazardous process? Now, when we come to, for example, the glazing and grinding is one of the hazardous process. Now, we will never think about this. In the glazing is done in the machine shop or something like that. But it is considered as a hazardous process. Now, for this hazardous process, there are certain guidelines given in the law. So, when you have this hazardous process being employed, or hazardous industry as it is classified. Say, for example, the paint industry is a hazardous industry, as we know, or any chemical industry, like we have is a hazardous industry. So there is a Schedule 1 of the Factories Act, which gives you the list of what are the hazardous industries. So, then in which case, you need to ask a question whether there are any dangerous operations. I am giving you too many sticks to you to beat us around, but nevertheless you should know, I have to do justice to this. So, because if there are dangerous operations, there is a list of dangerous operations which also talks about hazardous process. And people have to follow Yes, a set of procedures. Set of process for the purpose of compliance, and if it is not done, it normally brings forth a prosecution. So that's very important. The factory also has to have an ambulance room. Ambulance room.
Slide there also. Clicker.
It doesn't move there.
No, this is my.
Oh yeah. Sorry. Okay. Ambulance room. Right. 500 workers or more. If more than one, you can have one ambulance room, and if it is more, then it has to have one more. Similarly, we have canteen. If there are 250 workers or more, you have to have a canteen. Yeah. Oh, this is the old one, is it?
Why? What I had the morning. What is that?
Oh, then where from it's coming? Oh, that's coming from there.
This is my.
Yeah, okay, then you can take it.
Power alert.
Oh yeah, sure, thank you. So you have to have a canteen, and the canteen which is run, and the canteen which is to be run, it is to be run on a no profit basis. Many times you'll find it's run on almost loss basis only, because it's taken as a welfare provision. But the law doesn't look at that way. It is enough if you run it on a no profit basis. But if the employer chooses to forego even that kind of a revenue, you can't help it. But then no profit basis means what? Only the cost of inputs have to be taken into account and nothing else. You can't charge for the building, you can't build in the cost of building or fuel or whatever. This is the cost of input that is to be taken into account for fixing the price of any food items. So you have to have a canteen committee, like the safety committee, you have to have the canteen committee in equal measures between the representatives of the workmen and the management and so on and so forth. So therefore canteen, which is normally a bone of contention in any employee side, whenever you say canteen, I am reminded of one old anecdote which I heard from one of the very famous factories which is now closed in Chennai or the elsewhere in Madras. The factory which was multinational, they used to serve chicken in the canteen, and as per the settlement with the workmen, they are supposed to serve 70 grams of chicken. 70 grams of chicken. 70 grams of chicken. The workmen found that it has been less, they felt it is less. Immediately they called for a strike. And so much of loss has occurred to that multinational. Over a period of time, they also found it too much to run with this kind of workmen. They closed it and have gone away. That company is called Dunlop. Okay. So, it is the Dunlop which sponsored Mahabharat in our Doordarshan, if you remember well. Well, that's how it was. That was the anecdote which comes to my mind when you talk about the canteen. So, canteen is the place where normally the problems start. Okay. Then we come to an interesting part also, overtime wages. Overtime, see, before we talk about the overtime, what is the working hours? Working hours is normally 9 hours per day, 48 hours per week. There are a lot of problems and talks and news items, 12 hours per week and all that. I mean, they are taken into account for that they will work for 4 days and 12 hours per day. And so 48 hours is fulfilled. But that's not the case in the context of this law. If the moment you employ anybody more than 9 hours, you have to pay overtime wages. So overtime wages means what? Double the rate of the average rate of wages, double the rate. So ordinary rate of wages is what? Basic wages and allowances, excluding bonus. So you have to pay the double the rate of wages for that. Now if you go and ask some of the industries, are you paying double the rate of wages for overtime? Somebody will say, double the rate, sir, we pay 1.5. Some people will say, yes, we pay the double the rate. Oh, is that so? Then you are happy. But if you go inside, you will find they pay only double the rate of basic plus DA, or the basic DA and allowances. Because, of course, anyway, that is under dispute before the court. But because it talks about the definition overtime and such other allowances, and therefore we take an umbrage that is allowances part is not to be included. Therefore, only the basic and the cost of living index allowance like DA is to be considered. In our company we pay OT in the normal course for beyond 45 hours because we work for 45 hours per week, not 48 hours per week. So therefore, even beyond 45, we pay the double the rate, so it gets nullified. That's not a problem. But there are many companies which work only for 48 hours per week, and they pay double the rate of wages, either basic plus DA or basic DA allowances. So long as there is some kind of a amity between or understanding between the workman and this thing, I don't think we get into that. Anyway, so that is one point on the overtime. And the limit on overtime. This is yet another point where the problems come in. But this problem doesn't come to the industries, safety committee. For a simple reason, it's a matter of money and is an income for the workman. It's a work because he gets overtime at a very good rate, and therefore he is very happy, especially the organized labor. So limit on payment, as you know, there is a limit for that, including the working hours. It cannot be more than 60 hours per week, and they have pegged it at 100 per quarter. 100 per quarter. Now in the code, I think if I remember, it is increased to 120 or 140. So, but there are many companies which work only on overtime. You will find many people work 12 hours and minimum 12 hours. So that has become the order of the day, which has become, which practically obliterates, removes this particular provision from practical application. Weekly holiday, you have to give naturally. If you work for 6 days, you have to give 1 day weekly holiday. It can be any day because there is a provision available in the law. And sir, is the weekly holiday paid holiday? It doesn't say so. The law doesn't say so. The law doesn't say so. It doesn't say, when it comes to a holiday, under Festival Holidays Act, it says paid holiday. Here it simply says it's a holiday. So it need not be it is not a paid holiday under the law. Even the electricity did not like it. Okay. So it is not a paid holiday because the law doesn't say so. It is a holiday which has to be given. In any case, for his work, you are paying for the rest of the days. So you are not violating any law. If you, for example, his total wages divided by 26 comes to per day rate, right? Instead of doing it by 26, if you do it 30, some other rate comes. But if the denominator is 26, the per day rate and per hour rate for OT becomes very high. So you end up paying more when you do that. That's the only thing. But otherwise, if somebody is dividing it by 26 to arrive at the daily rate, there is nothing wrong with that. Well, here there is nothing here. Okay, I'll speak. Now, that is about the overtime. There is something called spread over. Spread over is including the rest in a particular day. When somebody works, he cannot be working for 8 or 9 hours at a stretch. So he cannot work for more than 5 hours before he takes a rest interval of half an hour, 30 minutes. Once again, if you look at whether this 30 minutes is a paid rest interval, the Act doesn't say so. The rest interval is not. It doesn't say so. Mic off now. Okay, thank you. It doesn't say so. So, if a particular shift is working for 8 hours, you can ask him to stay in the factory for 8.5 hours, including the half an hour rest interval. Okay, and for 6 days you do it 6 into 8, 48 hours. So you fulfill the law. So, therefore, when you calculate the rest interval, but when you work for 3 shifts in a day, then you cannot work for 48 hours. Yes, it is possible. You can work for 8 hours, provided one shift overlaps the other shift. That's what we call overlapping shifts. But the normal course, you cannot do this unless and until you get a permission from the written permission from the inspector of factory. That also you need to do. Well, now I would like to check with you, is that understood or any questions on this? Right, okay. Because I am deliberately going faster to do justice. Okay. Now therefore, including the interval of rest interval, the total number of hours that you will be expected, you can be expected to work in the factory is called spread over. That is 10 hours, or 10 and a half hours, or 10 hours. But in the exceptional circumstances, it can be given 12 hours, and because sometimes the rest interval will be more, and depending on the process, people have to take rest and all. For example, in the steel industry, when somebody is working on an OHT, overhead crane, overhead traction crane, now he may have to work on a very hot area, carrying the ladle which is there about 950 degrees. You are tapped it and carrying the ladle. Now those people will take 4 hours of rest, 4 hours of rest, sometimes 3 hours of rest, and so on. So therefore, including this rest interval, you can go for the maximum 10 and a half hours, and still more in exceptional circumstances, 12 hours. I talked about spread over. Then you have got the creches. You know creches. These creches are meant for the working women whom the Factories Act has envisaged long back, that we need to have creches in any place where there are 30 or more women are employed, and they have to follow certain guidelines. Now this talks about 30 or more women. But if you come to Maternity Act, it talks about same creches where it talks about 50 employees are working, which means it can be both men and women. So there is a kind of a dichotomy there. There is a dichotomy there in prescribing the eligibility or for the industry to follow. There is a restriction on double employment. Now, moonlighting, a subject which everybody was talking about. In the whole of the labor laws, this is the only place where it prohibits double employment, where one person cannot be working in 2 other places. There is a clear-cut, explicit prohibition, and nowhere else it is prohibited. This is the only place. Well, there is yet another place, but it is very veiled. That is Industrial Employment Standing Orders Act, where you can prescribe a condition of service prohibiting double employment under the Industrial Employment Standing Orders Act. Now, once again, Industrial Employment Standing Orders Act is applicable to the workmen. That means managerial people are excluded. Well, you look at a technological company, even the programmer or analyst and people who are dealing with this kind of a technology, they are considered as a workman. They are not considered as managers. There is a difference between the managers and the workmen, right? That all of us know about it. So, by definition, the Madras High Court has held that the technological wizards, like many people who work as programmers and so on, software professionals, until they hold a position of supervisory and supervision and control, they are all workmen. So if they are workmen and if that place is considered to be a factory, straight away you get hit by this position of double employment.
You talked about this restriction under the Factories Act.
Yeah.
But most of the IT services don't come under the Factories Act.
Yeah, I'm coming to that. Yeah, shop act. You're right. I'm coming to that. I was about to tell that. Now the thing is, the buildings where they work, they come under Shop and Establishment Act, Tamil Nadu Shop and Establishment Act. Now, Tamil Nadu Shop and Establishment Act does not explicitly provide for it, but they can prescribe standing orders. They can prescribe standing orders or regulations which can be certified. That is coming now. That in some of the, in fact, Karnataka had given an exemption. Karnataka had given an exemption for a period of 5 years for the technological companies from formulating their own standing orders. Now it is not there. That exemption is expired. So under standing orders, when you have a prescribed service conditions for the employment, then you get covered. That's what I was about to tell you. Here the law provides for it, there you have to provide for in the law, or in the terms and conditions. Which I think perhaps many of the technological companies are not doing it perhaps. That's what I understand. It is only to understand the curiosity part of it. So I thought I talked about it. Now annual leave with wages. Many of us are entitled to leave. Now the leave in a factory flows out of a fixed formula that for 20 days of actual work, you get 1 day of leave. So 1 by 20 is simple, for which you need to put in 240 days of minimum work in that particular factory, which will include the authorized leave also, and even legal strike is also included. Legal strike is also included. So therefore, having fulfilled 240 is, if they are not fulfilled the 240 in a particular year, applying this yardstick, he doesn't earn any leave in the subsequent year. And this particular act talks about only the earned leave, only the earned leave that is earned. It does not talk about medical leave, it does not talk about any other leave. So therefore 1 by 20, which means if he is going to work for 300 days, maximum will be 15, or mostly it is 40. We can say that. And he can accumulate maximum of 30 days. He can accumulate maximum of 30 days, and he can encash it at the time of, there is nothing called annual encashment here. You can encash it at the time of your separation from the service of the company. So accumulation of leave up to 30 days, no limit. Number of times you can avail leave is 3 times in a year. So the Factories Act even goes to the discipline area, that you shall avail only 3 times in a year. But well, that doesn't work in practicality. Accident. This is something which all of us are quite worried in a factory. Accident arises out of 2 conditions, as every safety professional would tell you.
This number of times leave can be taken 3 times.
Yeah.
A year. There's no restriction on the number of days, or 3
No, there is no
days?
restriction. 3 times.
Oh,
There is no restriction.
no restriction.
Because it also provides for his health. Accidents, as I said, accidents arise out of 2 conditions, two factors: unsafe act, unsafe conditions. In any accident, if you analyze it, there will be either unsafe act or unsafe conditions. So, including the road accident, all of us are. In road accidents, both of them exist. Anyway, so in case of death, we have to report to the Inspector of Factories within a period, within maximum of 12 hours, and the injured worker, if it doesn't report, if there is an accident, and if there is something called 2 types of accidents, reportable accident, non-reportable accidents, depending on the number of days that he is rendered incapacitated at home or so on. If it doesn't come for more than 24 days, then we call it a reportable accident. Then we have to give a follow-up report to the Inspector of Factories. Then if he reports it within 3 days or so, it is a non-reportable. So that's not a problem at all. So that is a reportable. Then we have to have an occupational health center. Occupational health center is required where there is a hazardous process is carried out. Up to 50 workers, factory medical officer on retainership, 5 first aiders, then you have to have a first aid box. 51 to 200, like this, there is a gradation as to how many doctors you can have, whether you should be part-time or permanent or retainer basis, and so on and so forth. So in any case, you have to have an ambulance room, I said. What is this ambulance room? It is nothing but a first aid unit containing the minimum number of material that should be available. including an ambulance. Ambulance may be there, may not be there, it is not a must. But ambulance room where the injured is taken care of with the first aid, that has to be there along with one a male attendant, or male or female attendant as the case may be. Then we have quality of personal protective equipment is also prescribed in this law. Now that many of them buys cheaper materials, putting the workers into risk. So it has to have a BIS standard or ISI or a BIS standard. That's very important. There is a particular rule which I would like to bring it to your notice: machinery in plant. See, you cannot, no machinery plant equipment shall be constructed, situated, operated, maintained in any factory in such a manner as to cause injury to the worker. And there is also methods of work. Now these two provisions you will find in almost every prosecution notices. These two will be on methods of work and also about the machineries. It will be there. Then comes an important section, which I am very sorry to say, many of the IR professionals themselves are not very aware, because it comes in the form of many other provisions which talk about punishment. This is the only law, this is the only section, 96A, the whole of the Factories Act, which prescribes simple imprisonment and fine to the occupier and manager. In all other cases, it will be imprisonment or fines. So more often than not, after the prosecution notices are issued and the reply is given, and conveniently when it is not found to be satisfactory by the inspector of factories, the occupier is dragged to the criminal court, where the criminal judge, the judge who presides over the criminal court, the first class magistrate, it should be not less than the level of the first class magistrate, he presides over it, and a regular criminal proceedings start against the occupier and the manager, at the end of which, invariably, from my experience, a fine is levied on 1 count, 2 counts, 3 counts, 4 counts, and so on. That is the number of charges that are levied against you. But this is the only law, this is the only act, this is the only section under the law which talks about both. I know cases where people have been convicted with a simple imprisonment until, at least until the rising of the court. At least until the rising of the court. The judge will come, you are found guilty under section 96A, you are hereby imprisoned till the rising of the court. He will say at 2 o'clock, he will go off at 4 o'clock, so between 2 and 4, he stands imprisoned. He stays in the same court, he stands imprisoned. Now, he may not get disqualified under the Companies Act. There's a different thing altogether. Because it is not more than 6 months of imprisonment. So therefore, it does not come under a disqualification mode of the Companies Act, but nevertheless it is an ignominy, if I call it, for that person. But then under what circumstances this 96A is invoked is, there are 3 innocuous looking sections, 41B, 41C and 41H of the Factories Act, where it is mostly pertaining to the procedure to be followed in case of hazardous process. Hazardous process. Where there has to be a compulsory disclosure of many items, including there has to be a site emergency plan. Approved site emergency plan. If you go to any factory, the first question you should ask, do you have a hazardous process? Do you have a site emergency plan? Site emergency plan will talk about everything, including handling hazardous substances, storage of hazardous substances, disposal, and the injury it could cause, whether the injury have been informed to the employees, whether it's been notified, whether it has been put on the notice board outside. It talks about scores of procedure. So if that is 41B, 41C talks about specific responsibility of the occupier in the hazardous process. Once again, then 41H deals with the right of workers to warn about the any imminent or immediate danger, where somebody comes and tells you, sir, this is going to burst tomorrow. Hydrofluoric acid is going to flow tomorrow. There's a crack, please take care of it. You don't do that. Tomorrow it is proved that he is right. Then you can be booked under 41H. So the 96A says, it need not necessarily all the three sections have to be violated. Any one of the thing has been violated, then you are automatically become liable for punishment under 96A. So penalty is maximum of 10 years of imprisonment with fine. It is under this law, Mahindra was threatened under in excise case. It is under this. Keshav Mahindra. Well, with that sour note, let me come to the limitation of prosecution. Well, this is 3 years, 60 days. 60 days. That is from the time the non-compliance or something like that, or the offence has come to the notice, he should take action within 60 days from that day. If he doesn't do it, even if he takes it on 61st day, he should at least come and visit and make a note and give you a report, non-compliance report or whatever. If he doesn't do it, on that score alone, the entire prosecution will fail. Any questions? Okay. Let me go to the Minimum Wages Act. Excuse me. In Minimum Wages Act, the there was one company in Velacheri, Raptacos Bread, which I'm sure many of you know, is closed thanks to the workman. In that case, Supreme Court has said, if you can't pay minimum wages, you need not run the industry. You have no right to engage workers. So that is the crux of Minimum Wages Act. The workmen have to be paid wages not less than the minimum as prescribed by the appropriate government. This is the crux of the entire act. Okay. So it is applicable to all the categories. If you look at the government notification, you take out the government notification, there are many scheduled employments. What is the scheduled employment? They have taken an employment where there are more than 1,000 workmen are employed in that particular industry throughout Tamil Nadu. Then it is a scheduled employment. That warrants the prescription of minimum wages to be given. So if you look at the scheduled employment, you will find even the minimum wages prescribed for managers also. Managerial person also, like managers, assistant manager. Then you find what do you call it? Supervisor, worker, unskilled worker, messenger, peon. Like this it keeps going. But for all the different, it even prescribes minimum wages for agricultural workers. Where depending on the depending on whether it is run with the tractor or with the bullock car, with the bullock and the yoke, like that, they classify and give the minimum wages. So the appropriate government in this case for the industries is the state government normally. Sorry. Now there is a national minimum wages board. There is a state minimum wages board. Now how these minimum wages are fixed? Let us understand. See, for the fixation of minimum wages, they do a survey, and of course there's nothing to do with the compliance part of it. But they do a survey, they bring a basket of different goods and services, and they are brought together and their appropriate weightage is given, and they measure as to what an average family of 4 members would require these facilities. So those services including cloth, food and so on and so forth. And all these are taken into consideration, and it is fixed by minimum wages to be fixed. This is how it is to be fixed by the government. But while fixing it, they have found, as per law, as per the minimum wages, there are 2 methodologies followed. One is by the committee, that there will be a committee for this. For every scheduled employment, there will be a committee. Like for textile, there will be a committee. General engineer, there will be a committee. Recently, there was a meeting recently which we attended, was about the garment industry, tailoring industry. What should be the minimum wages for plantation industry and so on. That is one way of fixing it. The committee members are tripartite and they discuss and they arrive at based on certain formula. Second is by the notification method. The committee is not formed. The government on its own suo motu they form. They come with a recommendation and they publish a notification calling for objection from those stakeholders as to whether they agree with this or not. They are seeking for the suggestion, and taking and considering all those suggestions, they fix finally, they confirm a notification. They confirm a notification with or without modification. Okay? So this is how the minimum wages are fixed. So while we fix the minimum wages, what are the components of the minimum wages? The components of the minimum wages is basic rate, cost of living index, allowance, and house rent allowance. Now Kerala government, it goes to the extent of even including city compensatory allowance for certain employments. Now this minimum wages, if you look at Tamil Nadu minimum wages book, there is one Mr. R.S. Sharma who is no more. He is a retired Deputy Commissioner of Labour and advocate. Their office brings out this minimum wages compendium, the latest every year. For every financial year they bring it out. So it gives you a very good information about what is the basic rate, what is the dearness allowance for every category of workers, class of workers, in every category of scheduled employment. So there it is the basic rate and there is a DA, daily rate. In Tamil Nadu context, the daily rate, daily allowance rate, dearness allowance rate, I am very sorry, extreme sorry. Dearness allowance rate, DA rate. The DA rate is revised every year and it comes and is notified in March to be effective from 1st of April of the subsequent financial year. In some states it is done every 6 months. In some industry, in some states it is done for every 6 months, and in some states it is done every year, every month. I think if I remember well, I think central is every month. I think that's how it is done. So when by bringing in March, and we can know it and we can appropriately provide it for the liability in our book of accounts. But more often than not, it is not the regular employees who get this minimum wages. They get much more than this. So who get, there is the daily rated contract workers and other casual workers who get paid. Now when I use the word contract worker and casual workers, I am deliberately using 2 words. One is a casual worker is what? A casual worker is the worker who does the job for you on a casual basis. Today Mr. X has not come, so you become a casual worker. And who is the employer there? The employer is you. That is the employer, that is the industry. Okay, I have to pay. But in a contract worker, I am not an employer. It is the employer is the contractor who comes under the Contract Labour Regulation and Abolition Act 1970. Right. Now, therefore, he is the employer. Then what are you? I am the principal employer. So this is the difference. So when we say casual employee, people who discern this point will first ask: is he a casual employee or a contract employee? If he is a casual employee, that means he is paid by the industry directly. then tomorrow the consequences are something more, which I will come to that later. Right. Well, methods of fixing, I said. Minimum rate of wages, basic plus DA, basic cash value, I told you about that. And government can fix, either they can fix a minimum time rate. That is, if you work for 8 hours in a day, 48 hours in a week, this will be your rate. For unskilled so much, semi-skilled so much, highly skilled so much. Or it can be even minimum piece rate. But where you have minimum piece rate, the rate at which he is paid per day should not be less than the time rate for the particular category of workers. You know, if supposing one time piece rate is 10 rupees, you have to make that the minimum wages says time rate is 100 rupees. So we will say that he has to make, she has to make, or he or she has to make 10 pieces to be eligible for this. Supposing she or he makes only 8 pieces, then 80 rupees, but the law says you still have to pay 100 rupees. So therefore the time, the piece rate, or you can even ask the person to produce more depending on your requirement. In any case, the person who produces so many pieces of product will purely depend on many other factors. So that's one. The third one is guaranteed time rate. Guaranteed time rate is whatever is done, whether it is piece rate or this thing, I will give you only time rate straight away. So the rate at which it is paid, it can be paid, but the total amount that you will pay, you can either make daily payment, weekly payment, fortnightly payment, or monthly payment. Now, this Minimum Wages Act also talks about how you have to pay. You have to pay it in time. In time means what? If it is less than 1,000 workers, then you have to pay on 7th, before 7th, on or before 7th. Or if it is more than 1,000 workers, you can pay on or before 10th of the month. If it is terminated, then you have to pay on the second working day. Whatever is payable, outstanding dues payable. Wages shall be disbursed without any unauthorized deductions. Well, it also talks about what are the authorized deductions, which you can do it, like product fund, ESA, and so on and so forth. It lists out what are the authorized deductions are there, including fine and so on. But you know, fine is a very, nobody levies a fine. If you go and see punishment as a fine, nobody will levy a fine because it's a big hazard. Because you have to first give a notice, then it should not exceed 3% of the wages, and deduction, total amount of deduction of the damage. I mean, you can do the deduction if there is a damage or loss, then it cannot exceed 1/3. All those hassles are there, and you have to give a notice, and the amount that is deducted in the fine, you cannot keep it. You have to remit it to the state government by way of a check or, not even check, I think demand draft and so on. So therefore, nobody levies a fine. Even if the service conditions provide for levying a fine, nobody does it. Either you give a warning letter, or straight away go for reduction in the rank, or reduction in the pay, or finally dismissal, depending on the gravity of the misconduct. Well, this talks about the procedure on a claim petition. I thought I'll have some time, but there is nothing much about this. If the existing wages are higher than the minimum wages, then the existing wages are protected. Supposing tomorrow you are paying more, and tomorrow what happens is the minimum wages you find is less, so you cannot go back and say I will pay only the minimum wages. Certainly, it is in the modern context, it is not allowed. Nobody will agree. But if you look at the year in which this law has come, 1948, so it can make the sense as to why and how they wrote this kind of a piece of law. Okay, normal working hours is almost equal to like what you find in Factories Act. See, Factories Act also was promulgated in 1948. This also came in 1948. So therefore, you will find many similarities. Overtime wages, yes, but the point is, in case of agricultural plantation, it is 1.5 times, not twice the rate of wages. Obligation of employers is paying the rates of minimum wages without deduction, observe directions, maintenance of registers, and issue of wage slip. You have to issue a wage slip to the concerned worker. Like what you have the pay slip, which is being given to the employees, they are also supposed to be given the wage slip, which is also provided under the present code. So the wage slip, how it should look like, is also provided under the Factories Act, because your contract labor is also a worker under the Factories Act.
Sir, excuse me.
Yeah.
This thing about adolescents and children you told, no? I saw in Factories Act also you said they
Yeah.
should be older than 14 years.
Yeah. Adolescent is 14 to 18.
They are allowed
Child
to
is
employ
before
even-
14. Yeah. The adolescent can work in a factory subject to certain conditions. They cannot be working in the night shift and so on and so forth. They cannot be put on hazardous process. They can work. But before you engage any adolescent, you have to explicitly conduct the medical examination and also inform the factories inspector and obtain his permission. So adolescent can be engaged.
even in
Child, of course, no question. Well, above 18 is okay. Therefore, you will find many of these apprentices who come to you, they will be bordering 18. They will be 17, 16 and a half and things like that. So it becomes a problem for many of the industries. So you need to write to them that we are engaging. But you cannot, many of the industries don't prefer that, because the apprentices are put in for training and work purposes in the shifts, whereas they cannot be put in that. That's the problem.
so in industries like the hotel industry and all also they are allowed to be employed. 14 and above is allowed.
But subject to these conditions. Subject to this, yes, they are allowed. Many of the hospitality industries, they employ
They
this.
employ.
But it's safer not to do that. And what they do is they employ, telling the inspector of factories that for the shop and the hotel comes under the Factories Act, of course. They tell the inspector of factories, they are all, sir, oh 18, sir, show me, dikhao bhai, kahan dikhao. Then he will say that, sorry, they don't have Aadhaar card, they don't have Aadhaar card. So in such circumstances, the inspector of factories has got the power to summon the factory's surgeon, called certifying surgeon. The certifying surgeon is the doctor appointed under the Factories Act by the government of Tamil Nadu for many other purposes. One main purpose is to assess the health requirement of the workers. For example, the canteen worker is to be assessed for his suitability to the canteen for every 6 months under section 67A of the Factories Act. So it has to be done by a certified surgeon or a medical officer as authorized by the certified surgeon. So the certifying surgeon is the person who is empowered to find out whether Mr. X was come from Assam, he is really 18 or not. If he finds it 18, then the particular person has not complied with the act, then he is liable for prosecution. Beyond that, you know what happens. That's all. Is it okay?
Yeah.
Right, okay. Now coming to Payment of Wages Act. Now Payment of Wages Act is 1936 law, very important act. It governs as to how the wages have to be paid, what are the wages, how it is to be done, and also to punish the employees for any non-compliance under the law, especially not payment of wages. Am I going slow? Okay. Yes. Here the appropriate government is the state government. Appropriate government means the government which can take any administrative action, including the inspection, enforcement, and prosecution. Applicability is, well, it covers factories, shop and establishment act, then catering establishment. You say what? It almost covers everybody. Almost covers everybody. Mines, plantation, and so on and so forth. And the government of India can notify any any type of industry to be brought under the payment of wages. Virtually everything comes under the payment of wages. Now, who is covered? It is the employees who are covered, whose salary is 21,000 and below are covered by this. So it means the managerial people are not covered by Payment of Wages Act. Kindly note it. Okay. So wages means what? Virtually it covers everything. Wages includes all remuneration, but it excludes your statutory bonus. It excludes statutory bonus. It excludes gratuity, but the exclusion also gives a qualifying clause. If the payment, a similar payment is made on the termination or separation of the services of the employee, and by the virtue of the contract of service, then it is covered. So what does it mean? Payment of Wages Act covers gratuity, but it doesn't cover the statutory bonus. That 8.33, 20% doesn't cover. It has got an implication. I'll come to that. It is also interesting to note, under the Code of Wages, which is going to come, which has been approved by the government, which has been approved by both the houses of Parliament, and is only yet to be enforced. Right? Date of enforcement has to be there. The wages definition is there. Many of you might have attended some seminars or whatever as to what are wages, how it is to be done under the Code on Wages and all that. That definition has arisen out of a Supreme Court judgment. And Supreme Court judgment, though it is a recent judgment, they say it has got its root way back in Bridge and Roof case in 1962. We will not go into that for paucity of time. But under the Code on Wages, the position gets reversed. The bonus which is excluded is included by the virtue of rule, one particular provision. The gratuity which is included is excluded. I am not sure whether the lawmakers have understood this. Now this is very significant, not for an organized worker, but it's very significant for a contract worker and the contractual obligation of the principal employer to pay the contractual charges for a given work to the contractor, right? Because virtually today the industry is run only by contractor, outsourced, right? And we have in industry there are 20 workmen and 2,000 contract workers and trainees, right? So there, the management is one of, not of organized labor, is one of contract labor. Well, contract labor has got its own advantages. I'm not going into that. Well, that we will come to that. That's the last slide. I only hope we have time enough that for that. When you have to pay, when you build a liability sheet for a contractor, what you will pay for the given work, you take the minimum wages into account as a benchmark. Then you add EF contribution, ESI contribution, PF contribution, ESI contribution. So the question comes whether I need to add bonus, whether I need to add gratuity. The guy will be only 22 years old, 24 years old. He is not going to get separated today. But the law enjoins upon you to make a provision for it. It may so happen some fellow is working for about 25 years with you and one day he comes off. So gratuity is payable on his death, right? Gratuity is payable irrespective of his period of service. You have to pay him in case he dies or in case he gets totally disabled. So where do you account for that? So that's where this problem comes. Do I have to account for bonus in the daily rate of wages than calculating his liability as part of calculation for consideration for the given job or not? So that comes into the picture. I hope have understood that. But that will become very pronounced. This problem will become pronounced once the code on wages gets enforced, not now. Today, the position is gratuity is included and bonus is excluded insofar as the law is concerned. So that is applicable even for the contract worker. For the, of course, regular employee, it's a part and parcel of the service condition. So there is no question about it. You cannot say I will not give you gratuity because you are the employer. I am talking about the principal employee's liability with respect to a contractual worker. Contract worker. There is also a set of people called worker on employee on contract. That I work with you for 2 years, 3 years, and then go away. There, this doesn't come. A contract worker is different. That's like you must have studied about contract. I'm talking about you must have known contract for service and contract of service. So this where so we are talking about contract of service. Well, what are the deductions you can make from these wages? There are a lot of, there's a list available here: absence from duty, fine, damage or loss, electricity supply, income tax, profession, social security case, everything. You can do that, they're all. But if you deduct anything as punishment or withholding increment, cutting the pay as a punishment, then that is not a unauthorized deduction. It is quite a authorized deduction that doesn't come under the deduction part of it at all. It is a punishment. Okay. Now, if the employee gives an authorization, if he gives an authorization to deduct from the salary, like the premium for the insurance and all, or for the trade union, subscription to the trade union, all these things will be authorized. But that has to come with the written authorization from the employee concerned. When I mean is, once again, those people who are covered, who draw salary of 21,000 and below.
Is there any limit on the deductions? What about deductions?
Pardon?
Is there any limit
on
what amount deduction? Say
yeah, not exceeding 50% of the total wages. But there is an exception for it. That is, out of the total salary or wages, you cannot make a deduction more than 50%. So that's the reason why many companies, what they have a priority deduction PF, ESI, which they have to pay, and the failure of which will attract penal action. And you've got secondary deductions, second priority deductions. But that will not exceed 50%. But if you have a cooperative society, or if the employee is a part of some cooperative society, credit society, or consumer society, where you have undertaken by way of an agreement with the society to deduct from his salary the demand that arise from the society on an every month basis, and that deduction included, the total deduction can go up to 75%. But that 75% clause exemption is not available under the new code. It pegs at 50%, including deduction for the society. Right? Well, it also speaks about fine, and you have to have a register of fines here. You will find many of the people, they will have a register of fine which is totally blank because they don't levy fines at all. Now there is one interesting section here which as an auditor you will not be very much concerned, but when it assumes a proportion of litigation you will be very much interested. There is a section 9 subsection 2 of the Payment of Wages Act which speaks about penal deduction of wages. If a group of workmen, 10 or more, working in concert, there has to be an understanding, and they absent themselves from the duty, and if they do so, and if such provision, if such contingency is provided in the standing orders or in any other contract, then the employer can levy a deduction not exceeding 8 days' wages for the absence from duty. For example, I'll tell you. Suddenly, a group of people will take, some 100 people will take CL today, casually. They'll apply and go, and the regulation will provide for casual leave. You need not even apply because it is contingency oriented based. But 100 fellows did not come. So how will you look at it? They are acting in concert, and they are absented from duty. So what do? You slap a notice on them saying that why you are not liable for a penal deduction under section 9(2) of the Payment of Wages. Everybody will give you a story, and you say that I am not happy with it. I am slapping 5 days deduction, 6 days deduction, or 8 days deduction. So what happens is, this deduction is a penal deduction which is justiciable. It can be challenged in law. It can be challenged. Anything can be challenged in any court. So when it is challenged, the Payment of Wages Commissioner will conduct a regular hearing whether that deduction is legal or illegal. If you are able to prove to the satisfaction of the court, yes, it is legal, they have done it in concert, there are two conditions to be fulfilled. One is they have done it in full understanding to strike work in a manner that will affect the work of the organization. One. Two, it is provided in the contract of service. For the workman, the contract of service is what? Standing orders. See, there are two instruments of contract. One is our regular appointment offer. Sometimes they provide for it the regular appointment offer. More often than not, that will not be there in any managerial appointment. In any case, is outside the purview of this law. Second is the standing orders. What is the standing orders? Standing orders enacted under the Industrial Employment Standing Orders Act, which speaks about his conditions of employment available to him when he enters the work. He understands these are my conditions of work. These are the terms and conditions of work. A permanent document till it is challenged and modified. Okay, that's what I mean. So this is the standing order, and it is provided in the standing order. If these two are fulfilled, you are rather empowered to deduct or make this penal deduction.
Sir, I have a doubt.
Yeah.
This is only for people with below 21,000.
I know where you are coming to. But we slap it even today, even beyond 21,000 also. Because it's not been revised. They are workmen. You know where? I'll tell you why. We'll be giving a notice not under section 9(2). I'll give a notice under the standing orders. So the guy is earning about 80,000 bucks as a worker, an operator. Is he not governed by the standing orders? So my emphasis will be on the standing orders provision, invoking it, but not invoking under section 9(2).
But what about in case like you have the pilots for the airline companies, doctors, all of them?
But are they are not, see, pilots are workmen. That is decided even by the Supreme Court. Pilots are workmen. But the point is, why they are workmen is, they don't hold the position of supervision and control. They are not managerial. Right? Therefore, in order to, that's why I always used to tell my people, if you want to make somebody as a manager, or he is holding a managerial capacity, in addition to, I have dealt with a few cases which are quite interesting, but I will not waste your time on that. But the point is, the gist of it is, you give him such administrative work, which will be distinguishing him as an administrator from that of an ordinary, normal worker. Even in one case, we have shown that particular person as part of ISO document. Okay. So I said he's an administrative man, he's clearing the bills. If he clears the bill, the payment gets paid, payments get made. So where is the question of his being called as a workman? That fellow, I personally went and argued before the court. So the pilots, they are not, well, I've come to that. So supervision and control also will entail that he has got a hold over a group of people under him. The group may be 2 or even 1 person. Even if he is a boss to 1 person, he is still holding a managerial and administrative control. But here is a person who doesn't have any. So therefore, and by the virtue of his work, and worker under the Industrial Disputes Act, it also talks about a worker, unskilled, skilled, highly skilled, technical, and so on. So it gives a row of functions in which the gentleman, the pilot, falls. So therefore, he is considered as a workman. But the question is about the penal deduction. If they have provided for under the service conditions, need not necessarily be standing orders. It doesn't say standing order. It only talks about service conditions, prescribed service conditions. If that is already available with them in the character, with carrying the character of the standing orders, and is available, and he is bound by that, well, I can impose penal deduction on him. Tamil if everybody has got a way to beat it around, and then finally it comes to the test of law. If the test of law finally doesn't prove you okay, then you are flat. That's all. Right? That's all it is. So, okay. Now there is you can deduct for the damage or loss. That's also there. Wage period, the same thing like daily, weekly, fortnightly, and monthly. Should not exceed 1 month. Wage should be paid on a working day only. Wages should be paid in current. This is the old one. Now there is an amendment. Sorry, I forgot that. There is an amendment. You can pay it even in transfer also. Transfer of money to the bank account. Wages may be credited to the bank account check. Yeah, that's given there. And you have to give the wage slip. Now, the Payment of Wages Act has been brought into the code as a separate chapter. There are 4 chapters corresponding to the case, which talks about payment of bonus also to the workman. And if the principal employer doesn't pay the bonus to the workman, that is contract worker, then if the employer doesn't pay the bonus to the contract workman, the principal employer becomes responsible. That's where our liability comes there. That is as a municipal. Second liability is the contract workman had to be paid the wages in time like any other person, and the contractor has to be paid his charges well in advance in a manner that he is able to fulfill his obligation of making payment of salary to his workman. You got my point? If he has to make a payment on 7th and if he has to fulfill, you better gear up your finance department to pay it on 1st or 2nd or 3rd or whatever. That's what it says. But there we have raised a basic objection. I remember we fought in the ministry. The payment of charges in consideration of the work done is not depending on only the workman. Fulfillment of contractual obligations. If he doesn't fulfill the contractual obligation, where is the question of making the payment of contractual charges to him? Right? So therefore you cannot, irrespective of the charges, if he doesn't do anything and say, I want my consideration in the form of contract charges, how do I pay? But the ministry had turned deaf ears to our point. So that portion of law will come into existence once the code on wages is enforced. And one point I just want to tell you. Now we come to the payment of bonus side. Do I go a little faster? No, this is okay. Pace is okay. Now payment of bonus act, we know there is a statutory bonus, minimum 8.33, maximum is 20%. It is arising out of profit sharing by the employer to be shared with the worker, or employee, not worker, employee. And if the profit is such and calculated as per the computation sheet, which all of you know, then the maximum percentage of bonus that you will pay is 20%, which is law. But more often than not, we end up paying more in the form of ex gratia or whatever, including our group. So the payment of bonus act thus rendered absolutely useless there. But still, that is the one law under which many disputes used to get raised before the Labour Department. You will find you have so much of disputes under payment of bonus act. But now it is reduced. So, bonus is calculated on basic plus DA, and to whom it is payable for those employees whose salary is less than 21,000. Now, out of if the allocable surplus is available, then you will pay 8.63 or little more, but less than 20, depending on the computation sheet. But in any case, you cannot pay more than 20% even as per this law. You can also devise a scheme of payment of bonus based on production and productivity under section 31A. And in any case, there also minimum is 8.33, maximum 20%. But the criteria need not be based on the profitability, but based on production productivity. That's all. Now, this bonus act was in 2016 was amended. The section 12 was amended. What is the section 12? The section 12 is talking about making a payment of bonus beyond 8.33, where the salary exceeds 7,000 rupees, where the wages salary exceeds 7,000 rupees. Your salary may be anything, but for the purpose of bonus act, it is fixed at minimum 7,000 rupees. So when you do the computation, when it is below 7,000 or 7,000, take it that the salary as being 7,000. You pay, if there is no allocable surplus available, then you pay 8.3, no questions asked. But if it is crossing 7,000, they have brought in one more element called minimum wages. That is the amendment they brought in 2016, which is effective from 1/4/2014. We have filed for the retrospective application. We have filed in Madras High Court. We filed a writ petition against this. If it exceeds, where the salary exceeds 7,000, we can say it's a kind of a notional salary. It's not actually a drawn salary. But there could be some salary which is less than 7,000 also. But basic plus DA added together nowadays, there is nothing. Unless and until it is somewhere in the northeastern states. You know, when there was a discussion about the code on wages, all the workmen, all the ministry, everybody, secretary are all talking about, sir, minimum, there is something called national minimum wages, national minimum level of wages, NMLW, which is fixed at 176 rupees today. That is, it's only recommendatory. That is, the central government has come out with any minimum wages that you fellows will prescribe in any states should not be less than 176 rupees today. When we were out talking in the ministry, it was 150 rupees. Immediately the northeastern states secretaries, they said, sir, it is very high for us. You reduce it below 150. We cannot afford to pay. There are hardly industry. If you fix it, the industry will fly away from our states. Assam, Meghalaya, Nagaland. Even Assam also, I mean, they were scratching their head to say or not. But they did say that. So, what I mean is, there could be basic plus D even less than 7,000 also. That's what I learned at that point of time. Then. So, where it exceeds 7,000 or it exceeds the minimum wages, it is that wage becomes, whichever is higher, becomes the point for you to calculate the bonus for the calculation, I mean for the payment, Where the salary or wage of an employee exceeds 7,000 rupees or the minimum wages for the scheduled employment, for that particular type of employment, as fixed by the appropriate government, whichever is higher per annum, per mensa, the bonus payable to such employee under section 10, which talks about minimum 8.33, as the case may be, under section 11, shall be calculated as if the salary or wages were 7,000 rupees or the minimum wages whichever is higher. It is an as if wages. So, minimum, what happens is in all the major industries where the salary is certainly much higher, we take as the benchmark, the minimum wages as the benchmark for calculation as 8.33 or 20%. Even for the purpose of computation, that's what is taken. Okay, that's one point. Any doubt, any points? This act is not to apply certain class of employees, where it's given the LIC, Siemens, so on and so on. There's a big list. A notable one is, I may draw your attention to 5 employees employed by 5B, that is universities and other education institutions. Bonus is not, the statutory bonus doesn't cover them. Right? And institutions including hospitals, chambers of commerce, and social welfare institutions established not for the purpose of profit. So I think you don't pay bonus either. Do you? No. Because I think it's not for the purpose of profit. So universities, they don't pay. I'm not stirring the hornet's net, I suppose. In universities and education institutions. Let me quickly go to the next slide. Employees employed by Industrial Finance Corporation, so on and so forth. There's a whole lot of central institutions which are not covered by this.
But they will be having some alternate mechanisms. Right?
No, yeah, mechanism by the virtue of the administrative order. But they may not call it as a bonus. They may call it as a ex gratia or special allowance or special
control.
But financial institution, I have my own doubts whether they will have even any alternative stuff formula. But the government is empowered to come out with a notification taking into account the capital structure, objective, and so on and so forth, and declare it that in spite of non-provision, they can still come under the provision of the payment of bonus act. So pray to God that it doesn't happen. That's the whole thing. That's okay. Now coming to important thing is payment of gratuity act. Maximum is 20 lakhs as we know. Once upon a time, long back, which some of you may be knowing, the gratuity was calculated based on per day calculation, and you are paid, the employees were paid 600 days of wages as the gratuity. That is the maximum. Those days are gone. So it is Gratuity Act is what? 1972. Right. To provide for that. Minimum eligibility is 5 years of service. The amount that is maximum payable is 20 lakhs. And quantum, how do you calculate? Basic plus DA divided by 26 into the number of years of service. basic pay plus DA into number of years of service, 15 into 20, 15 by 26. That is, the idea is that you pay gratuity 15 days of wages or salary for every completed year of service or for part thereof in excess of 6 months. So, who is the, how the eligibility, at least you should have put in 30 days of service. And the point is, in case, I mean, that's payable on superannuation, resignation, retirement, termination. But in case of, as I told you already, in case of death and total disablement, the eligibility period is not counted. That is 5 years of service is not there. But many times, some of the people will be encountering you. Sir, what about 4 years, 9 months? Because 9 months and above is 1 year now. 9 months. So it becomes 4 years, 9 months. You will count as somebody has worked for 4 years, 9 months and he is buzzing off. Will you pay this off? We have taken a stand and legally also. Yes, initially he has to have 5 years of service. Otherwise, why the law should say 5 years of service? But subsequently, when you go and if there is a fraction, then you may add it as 1 year or whatever. But the point is, unfortunately, a single judge of Madras High Court has said in Metur BSL case, 4 years, 9 months, I can see brighter faces from those sisters sitting there. So, but that is not supported by many other courts. It is only in Madras High Court. If you go to Karnataka, they will say 5 years only. If you go to Kerala, they will say 5 years. If you go to Delhi, 5 years. Even Supreme Court has not said so. So therefore, it becomes appealable finally. But Metro PSL, I don't think they have done any appeal. So anyway, but 5 years of service has to be there. Please take it in your mind. And there has to be a continuous service of 240 days in a particular year. That's very important. See, many times people who are absenting very frequently, in a particular year, they would not have put in 240 days of continuous service. What is the continuous service? Section 2 capital A, it talks about continuous service. So, if you, as per that formula, if they have not put in continuous service for 240 days in a particular year, in our calculation, we exclude it for the purpose of computing the number of years of service for gratuity. Right? You might have come across some of the audits in our company. There is a forfeiture clause. You know, even if God comes, He cannot forfeit your provident fund. Because it cannot be charged, it cannot be assigned, it cannot be forfeited, it cannot be attached. Provident fund, there is a particular section available for it. What about gratuity? Gratuity is a gratuitous payment for the service rendered by you. But the courts have held that is no longer a gratuitous payment. It is a payment, a part of the social security. You need to pay it, better pay it. So, but nevertheless, there is a forfeiture clause available only for gratuity in case if services are terminated by an act, willful omission leading to damage or loss to the employer, the extent of such loss can be recovered from the dam, provided that fellow is put on notice. He is given a notice, seek for explanation, then only you can do that. There is once again, there is a interpretation for this, I'll come to that later. Second is, you can forfeit partially or wholly if the services are terminated for any riotous and disorderly behavior or for moral turpitude. Riotous, then disorderly, moral turpitude. For this, if it is proved in the court of in the inquiry, you can give a notice, then deduct it. What is this moral turpitude? Supreme Court has defined it as moral turpitude is a vile and depraved act. You have to look for a dictionary for other things. Vile and depraved act which is very, very condemnable, which will be considered to be a depravity. I don't know how to explain depravity. For example, a murder is an act of depravity. So, if that kind of a thing is done, if any act or riotous, there is a strike, people create a riot and they smash everything, like what happened in Simpson once upon a time in 1972, then you can give the notice and forfeit the gratuity for the loss that either partially or wholly. But there is an interpretation for this in the Karnataka High Court. It said it is only for a criminal offence that proved to be so, arising out of this application of offence, you can do that. You cannot suo motu apply this for any kind of act unless it is taken to the criminal offence. Well, but though there is an interpretation that is not followed by many employers. In fact, application of this by many employers itself is far and few between, in my opinion. So, this is not, but forfeiture is certainly applied. It can be applied. This is the only. Then another interesting thing is, any deduction can be made from the gratuity. Sir, he is leaving. I'll adjust my notice pay in the gratuity. Strictly you can't do that. There are many court cases, case laws where you provide an official accommodation for the employee, and if it doesn't vacate in time, in spite of the notice being given, then the value of the accommodation so rendered can be adjusted in the gratuity. Even the cooperative society dues cannot be attached, cannot be deducted from the gratuity. That is Madras High Court says in state transport case. So therefore, the scope for you to deduct anything, in as much as you, first of all, you cannot touch Provident Fund. Now you cannot touch this also to a very large extent, if I may call it. So the gratuity becomes a foregone social security payment that you must make to an employee when he separates from the service. Unless and until there is a compelling circumstance which you feel can be fought in the court of law for him to do that. For example, your gratuity comes to only 3 lakhs or 5 lakhs. Finally, you will end up paying 4 lakhs to the advocate in defending that in the court of law. So you need to see the balance of convenience also for the employer. But there are employees who say that no, certainly not. I will have to prove it to the rest of the people that they cannot get away with it. So there's another point. So there's a point and counterpoint for everything, as you know. Any questions on this? Now coming to Maternity Benefit Act.
One question on that.
Sorry, yes.
In case of death.
So 1 minute, sir. In
case of death, there's no period. There's no period, 5 years.
Oh no.
So the question is, to whom does it get paid to? There's
Very
no
good.
clarity.
Good.
There's no nomination clarity.
Yeah, very good. That's a good question. In fact, I should have touched upon that. There is a nomination under the. Well, there are two things. You have now provoked me to think something more to tell you. The gratuity is to be paid within 30 days from the cause of action. And if you don't, now the thing is, the law says that fellow has to give a form. It has to be, and he has to claim it and all that. Even if he doesn't claim it, you have to pay suo motu within 30 days. And if you don't pay, it attracts interest. Simple. What is the interest? The interest that is being declared by the government from time to time. Normally it is 10%. Now, Madurai bench has said in one case, it is 8%. Yet another judge in Madras High Court sitting in Madras bench said, it is 8.5%. So I am really confused now what to follow. So I went back to, in one particular case, I went back to, you have to give the benefit of doubt to the workman there. And therefore I went back to 10%, which was given by the central notification number. So 10% is to be paid interest, simple interest rate. Having said that, to whom it becomes payable? It becomes payable to a nominee. Now, nominee definition, the dependent definition is fairly truncated in the law, but does provide. But as you know very well, there is a difference between a nominee and the legal heir. Right? Nominee has got a right to receive the money, but enjoyment right rests with legal heir. Right? So therefore, what we do practically is we take a nomination, all right, and we wait for the if there is no objection coming from anywhere. In spite of that, we seek for legal heirship certificate. And if the illegal heirship certificate is given, as per that we pay. That is absolutely, it will not have any controversy. In case there is a controversy, how it will arise? Two things. One is about the inadequate amount, perceived inadequate amount. They feel that what you are giving me as a gratuity is not correct, incorrect calculation. Second is who is entitled for that as a dependent. So if these 2 points come, it's provided in the law, and I also advise the companies, you go to the controlling authority. Who is the controlling authority? Is the authority designated to deal with the gratuity matters in case of this kind of a problems. You go to controlling authority, deposit this within 30 days, finish it, and give him a covering letter and ask him to conduct the inquiry and disburse the amount. So you don't hold the baby, thus making a interest payment of 10%. Unless, unlike ESI and PF, there is no damage prescribed here. Penalty is not prescribed here. But there is certainly a penalty. I mean, there you have to pay the, there's a penalty in the form of interest for us. There is interest and penalty, here is only interest. So therefore we say, you go and, even if you have the slightest of dispute coming from, you deposit with them and ask him to do the adjudication over that, because he has got powers under the code of code of civil procedure. He can exercise the powers under code of civil procedure and conduct the inquiry and then disperse the amount as he deems it fit, because he has got enormous power. So that's what we do. Is that correct? Now come to Maternity Benefit Act. Now it covers, factory, mines, platform, plantation, and so on and so forth. Shop and establishments also where there are 10 or more employed. But it will not apply to those cases where ESI applies. See, the ESI basically provides the medical benefit, disablement benefit, maternity benefit to the employee, and also the medical benefit to the dependents of the employee who are covered by the ESI. Excuse me. In the maternity benefit, the remuneration means, the wages mean the entire remuneration, excluding the incentive bonus. And who is a woman who is defined as a person who is employed there. And by a recent amendment, thank you. So nice. Hold on, huh? Then I will skip something. I think I have to skip maternity.
Yes.
Okay. Now there is an important act. So there is a commissioning mother is the definition which has been introduced, where it also there's a means a biological mother when her egg is used or any other person also can, but it is a surrogate mother, it's the commissioning mother who is employed. Now the woman shall not be employed for 6 weeks before a delivery or miscarriage or MTP by the employer. Now broadly, what is this maternity benefit? As you know, many of you have known from the news items. It is the 26 weeks wages. I'll put it this way. Maternity benefit is equivalent to 26 weeks wages given to a prospective mother for her to take care of herself and also the child during this period, out of which before the delivery not more than or not less than 50% of the period, that is 13 weeks, are to be given for her to leave, as a leave. It's a paid leave. For this, she has to necessarily claim it, not that it will come automatically. So, there is a claim procedure available. Let us understand that. It is, in my opinion, is one of the best acts that can take care of the women maternity point, because even if she miscarriages is there, necessarily the rest of the period, the 13 weeks had to be given to her for the purpose of, 12 weeks had to be given to her for the purpose of taking care of her health in case of miscarriage, MTP or whatever. And most importantly, when she is working also, the work is to be assigned to her in a manner that doesn't cause any inconvenience to her from carrying on with her pregnancy, or it cannot be an act which is likely to interfere with her pregnancy later. So, standing position and working, in many cases you will find many of the assemblies in automotive companies, they have to stand and do the work in the assembly line. It is prohibited. It is prohibited. And the point is, in case the woman dies during pregnancy or delivery, the benefit doesn't stop there. The entire benefit has to be paid to the dependent, the husband or whosoever is there. Maternity benefit must be granted even if the period of benefit overshoots the contractual term. For example, in one case, the person came and applied for maternity benefit, and she has been doing that. Well, her normal contractual period got terminated by the employer. It's a contractual period, contract terms of 3 years or 2 years, something like that. So the organization stopped it. The court said nothing doing. It may overshoot, yes, for the rest of the benefit also, for the rest of the period beyond the contractual point, have to be paid to her in advance. Or you pay it every month. She gets a medical bonus of 3,500. Maternity benefit for 6 weeks following the occurrence of miscarriage or UTP. For tubectomy operations, same thing is given. Leave or illness arising out of pregnancy, miscarriage, she can take care of herself for about a month. With wages, of course. Everything is with wages. And they have to run every establishment who has got 50 or more employees, they have to run a creche. It doesn't talk about women employees. So we said, is it women employees or women? Suppose there is no lady employee at all, do I have to run a creche? So that they are not able to make any clarification. But we feel that by the virtue of its the construction of the sentence is such that 50 workmen, there should be 50 women. But that is contrary to the spirit of law. Because if there are about 20 are there, just because you don't have 50. So you should be, the women should be present. Women should be present, in which case you can have a creche either alone or collectively, or you can even outsource and run the creche. And every establishment shall intimate in writing and electronically to every woman at the time of initial appointment that such benefit is available. What we do is that you are entitled to this, that as per law. This is what we say in our appointment order. But nowhere it says that you are entitled to maternity benefit under this particular law. We don't say. But all this thing will get corrected with the new law. No mention about the deduction of normal deduction. What are the deductions that you can make out of this maternity benefit? PF, yes, you can deduct. ESA you can deduct. But any other deduction you have to keep it in arrears. That's what we understand. Though it doesn't say so. If employed with any other employee during this period, then benefit can be stopped. So no moonlighting. Well, that's about the maternity benefit in short, slightly rushing through. We have the National Festival Special Holidays Act. We know national holidays, there are 4, right? There are 4 national holidays. There are 5 festival holidays prescribed, which may be chosen by the employer in consultation with the employee representatives. And if there is going to be a dispute about that, then it is the Inspector of Labour, who is the appropriate government, or the Inspector of Factories, as the case may be, will adjudicate upon that and come out with his own list. But totally there are 9 days of holidays envisaged under National Special Holidays Act, National and Festival Holidays Act. It has to be, they are all paid holidays. Now, it is applicable to everyone except in one case. I will come to that at the end. It's a very interesting thing, but anyway, many people don't follow it. There is a special holiday. What is a special holiday? There is in 2017 there was an amendment. When a lot of employees, they were rushing to, they went to Pongal and then they wanted to come back. No buses. So Tamil Nadu government, at that time the Chief Minister was Mr. O. Paneerselvam. So they found, the Tamil Nadu government found that these bloody employers, if you ask them to issue a holiday under NI Act, Negotiable Instruments Act, you don't do that. But private employees will not do it, because private employees are not covered by national declaration of holiday under Negotiable Instruments Act. There's one famous case law also there involving bimetal bearings, for information. Anyway, so you cannot be given holiday under any other law. It's not a festival holiday. Pongal is over. So you cannot be, it is national knowledge. So he hit upon an idea, not he means what, that the Labour Department will insert an amendment that the government can declare any day as a holiday considering the special and the emergency and contingencies and so on and so forth, and that holiday will be a paid holiday under the Act. So it was everything, one section was inserted and the caption was modified, and the Special Holidays Act has come. That's how those people who are coming back, that you have to pay wages for the salary for the absence arising out of the coming back. It doesn't say so for coming back, they simply said, but it is to take care of those contingencies of people who have to come back after Pongal holidays. It has been done. That is the background, nothing great about it. Now, you have to pay the wages, yes, and they have to declare. Every year, the employer has to declare, give a list of holidays to the authority, Inspector of Factory or Inspector of Labour, as the case may be, depending on Shop Minister or Factories Act, and then that has to be done. So we need to see whether it has been done or not, because if it is not done, any fellow can pull you up and levy a fine on that. And mind it, tomorrow's holiday is not coming under this Act. That is a separate law by itself. Do I wind up? Yeah, it's coming. Yeah. Yeah, I'll skip that. Yeah. Okay, done. In order to become entitled for this wage, for the holiday, I'm talking festival holidays. National holiday, you have to give it. And the people ask whether they can work on national holiday, festival holidays. Yes, you can work by giving appropriate notice to the inspector and then putting on the notice board and also informing the employee concerned. But we don't encourage it in practicality. But if you have to be entitled for festival holidays, what happens is, there was a case where there was a strike for 2 days. Then after 3 days, Pongal holidays came. So the employer said, you are not entitled for the Pongal holiday with wages. Sorry. Though it is declared as a festival holiday, I will not pay. Citing a Tiruchengood case, Tiruchengood cooperative case, where it said, there is a provision. Then the previous 90 days preceding the arising of the law, arising of the festival holidays. Say today is festival holiday, 90 days. And preceding that, you have to work, you should have worked continuously for 30 days. Of course, providing for intermediate rest holidays, holidays of rest. You should have worked for, you are not worked, you just broken by your 2 days of strike. So I will not give you Pongal off. That was upheld. That was upheld. That instantly. So the wages for this has to be paid along with it, monthly basis. Well, okay, this I will skip. Well, we have EPF, Employees Provident Fund Act, and ESI Act. This is the ESI Act. I'll tell you briefly.
Yeah, okay with this.
You are okay with it? Any question on the EPF and ESI Act?
Cover the contract.
Contract Labour Act I will come. Any question on EPF and ESI Act, so that I will skip it conveniently for want of time. I've come with a big platter, but I don't have people to take it anyway. Anything on that? People who join after 1/9/2014, unless and until their salary or wages is less than 15,000, they are not covered by the Provident Fund Act. I think everybody knows it. All the auditors would know it certainly. ESI Act is to follow the eligibility for the ESI Act is 21,000 and below. 21,000, which may get revised to 25,000.
I have a doubt in maternity benefit. I have a doubt. There was a case where a person went on maternity leave and the lady was given the entire benefit as per the law. The end of it, she took 2 more months of leave, which was gone on loss of pay. After that, she resigned from the job. There's no specific that could be done.
No, she has availed maternity benefit. Then the normal leave has been taken over.
Okay.
And then she was on loss of pay. And then she has resigned. I know one case. Pardon me to say that. The lady doctor came and joined the company. After 4 or 5 months, she went on maternity leave. She availed that, at that time it was 12 weeks of leave. No? Long back I'm talking about. About 25 years back I'm talking. There was a case. So 12 weeks availed. She came back, worked for 15 days. She resigned. It looked as if she had joined the company only to avail the medical maternity act. It's perfectly all right. You can't find fault with her. So here it is still.
One of our clients asked this question, but we said there's nothing specific. So I got to confirm from you.
Yeah. Anything on the EPF Act and ESI Act? Yes, sir.
Is there a category of employees who do not have the ability to subscribe for the Provident Fund and only go for, do not have the EPS facility, but they have only the EPF facility?
No. Actually, people who are joined the organization, the employer, before 1/9/2014, they were covered. They may be serving even now, but who joined the Provident Fund before 1/9/2014, they were and are the members of Provident Fund scheme employees pension scheme and deposit linked insurance scheme. What we call employees deposit linked insurance. We call it IDLI. So all the three are covered. People who join fresh, they are not seeing PF at all before. They are joined. If their salary is below 15,000, they are entitled to be a member of Employees Provident Fund Scheme, Employees Pension Scheme, and IDLI scheme. Right. If their salary is above 15,000, when I say salary, once again, it has got a lot of connotation here, whether it is basic, DA, or basic plus DA, or what is basic. I'm not getting into all that. This is a complicated stuff. You have to give me 3 hours to talk about EPF Act. So I don't venture into that. If the wages or salary is above 15,000, you have got every right to say he's an excluded employee, I will not enroll you into the EPF Act. But you are a benevolent employee. You are allowing to become the member of the Employees Provident Fund Scheme. But he cannot get into Employees Pension Scheme. So that means there will be employer contribution 12%, employees contribution at 12%, that will be intact. There is no question of diversion of the employer's contribution to the pension scheme. But whereas the first category which I talked about, 15,000 below, 8.33% of the 12% will be diverted to the pension account and he will start earning. Right. This is what I'm saying. You got it clarified, right? Thank you. Right. By Mahesh has dictated to me I should go for the Contract Labour Act. So I will obey his order. Well, any question on ESI? Actually, ESI is one of benefit for the company. Kindly say to it that ESI is paid up to date, EPF is paid up to date. If that is done, all the problems are solved there, because in both the acts, the implication for the employer is he has to pay both the contribution. If he has not paid the contribution, he has to pay both the contribution, number one. Number two, he has to pay the interest, simple interest, sorry, it is a compound interest. It's not a simple interest, it's a compounded interest of, now I think it's 12% now. And then he has to pay damages to the extent of maximum 25%. So it will be heavy amount. The damages ranging between 5 to 25% depending on the period of default. More often than not, these fellows will fall in the either 15% or 25% slab. It is highly damaging for the company, and it can go to the extent of recovery notice, and then sometimes attachment of accounts and so on and so forth. So these two are very, very important from that point of view, from the audit point of view. You have to ask the employer to produce the latest. One is the default of the employer stated for the employees can be found out. But what happens to the contract employees? Because if that fellow doesn't pay, every damn liability is on the principal employer's head. So therefore, you have to ask for the proof of the payment for the contractors. Now, of course, there is one more thing for you to check is GST payment. So, having said so, I will move to. I will really rush it through. Of course, there is one point in the Provident Fund. There is a concept called international worker. For international worker, for the entire salary, the PF is to be paid. And international worker is the person who is employed by the foreign company but working here for us here, or our employee working abroad. That's also international worker. Employee deposit in insurance scheme. See, one more thing is we pay 12%. Actually, the employer pays 13%. You know that very well. So 12% is the contribution, 0.5% is towards this IDLI, and 0.5% is the administrative charges. So your liability is 13%. So when you calculate the actual liability for the employer, it is 13%. Employees Compensation Act is very important act. I'm skipping that.
Yes. We go to Contract Act.
Contract Labour Act.
Yes.
Yeah, correct.
Since you told me I've dictated.
What is the most irking point in the conflict? This conferment of permanent status of workman, I'll just make a fleeting mention here. Because making some worker permanent, if a person, your own employee, I mean casual employee I talked about, if somebody is working for 480 days, 480 days in a matter of 2 years, he is deemed to be permanent in your organization entirely, is that he becomes permanent of the employee. The whole of the labor law, the permanency, the word is used only in 2 laws. One in this law, which is a state law, and is a central law called Industrial Employment Standing Orders Act, where there is a classification: temporary employee, permanent employee, probationer, trainee, apprentices, and so on and so forth. So these are the 2 laws where the permanency is talked about. Otherwise, there is nowhere else this a permanency is talked about, just for information. So you can ask the question whether there is any, but this doesn't include contract labor. This doesn't include training. This is for those people whom you pay as a salary directly, and this is only with respect to contract work. It is only to worker coming under the definition of worker, not for a managerial person. It doesn't cover retainers also. Industrial Disputes Act, somebody talked about retrenchment, right? The gentleman is gone, I think. The person who asked about retrenchment. Industrial Disputes Act talks about the retrenchment, layoff and all that. And mind it, the layoff which the newspapers mention about the technology companies is not layoff, it is actually retrenchment. Retrenchment is a permanent cessation of service forcibly brought in by the employer on the employees following the certain steps of law. Whereas in Industrial Disputes Act, layoff is the temporary suspension of employment relationship for the period not maximum of 45 days. So the layoff which this law talks about is different from the layoff word used by the newspapers for offloading the employees for the purpose of, in technological companies, because they have borrowed that layoff word from US. There the layoff is a permanent retrenchment. So in UK the word they use is redundancy. Well, I skip all this, straight away come to Industrial Employment Standing Orders Act. I will not touch upon that. I have already talked about it now and then. Now, Contract Labour Regulation and Abolition Act. Now, this is a most used and most abused act in every term, in every meaning of the term. Well, we know the benefits of contract labor. I don't have to tell you about this. Now, whom does it apply? It applies to any industrial establishment, or even for the matter, shop and establishment also, where you employ 20 or more workmen, and also applies to a contractor if he employs on day-to-day basis 20 or more workmen. Why? This is prescribed this. Two prescriptions. The contract, the employer, here there is a word called principal employer and employer. A contractor is an employer, and he is being asked to do certain work on behalf of the principal employer, which the principal employer are supposed to do, but it is contractualized and given to the another agency, who also either works in your premises or may work in their premises. For example, BD workers, they are contract workers, but they are also direct workers also, BD workers. So therefore, the establishment has to register first under this act. So that is very, very important. Very, very important. Similarly, the contractors whom the establishment engages, if he is engaging 20 or more, then he has to obtain a license from the licensing authority. Right. If there are X number of contractors with me today, tomorrow it becomes X plus Y. You have to amend the registration certificate obtained for the purpose of engaging the contract and contract labor. This is very important because sometimes the lack of these documents make the employer liable for regularizing the contract employees. Well, that has been disputed in the upper court. Fortunately, we don't have, because Supreme Court has said there is no automatic absorption of contract labor. Okay. What is the implication of engaging in the contract labor? If the contract is genuine, then the contract labor is not liable, or you cannot raise a dispute to become the regular employees of that establishment. If the contract is sham, this is the word used, in the National Water Workers Union case, SAIL Water Workers Union case, if the contract is sham, and the holes can be picked in that for reasons which are narrated, then the workmen they don't become suo motu your workmen, but those workmen can raise a dispute in a manner prescribed under the Industrial Disputes Act and seek for regularization of their services in that particular establishment. GMR, you might have heard GMR, who ran a big establishment, contract establishment, for pushing the trolleys in Delhi airport. They were totally affected by this. They didn't have proper contract, I suppose. Finally, the Delhi High Court has said that they are your employees. And how many people? More than 1,000 people. I think they had gone on appeal. I don't know whether they're spending or not. I don't have this. But I'm only trying to cite an example to give you the extent of damage it can create on the fortunes of the employer. Now, here also you have a contractor, there's a principal employer, the occupier is there, appropriate government is the state government has given the Industrial Rules Act. Wages, the definition is Payment of Wages Act. That's the reason in the initial stage itself I said, what is wages, whether bonus and contract, gratuity are payable or not. So that's the reason I mentioned there, because the wages under this law is derived from the Payment of Wages Act 1936. Now, I think this is all administrative thing, but what does the law say? What does the law say? The law says you shall not engage contract labor on perennial jobs. Just I'm told. What is the consideration for the government? The government has to consider whether the process, operation or any other work is incidental to or necessary for the industry, so there you cannot engage. Whether it is a perennial nature, whether it is done ordinarily by regular workmen, the regular workman is also doing and they are also doing it, then they need to think about for what. I will come to that later. Whether it is sufficient to employ considerable number of whole-time workmen for such jobs. They have to consider all this and come to a conclusion whether in a particular job the contract labor can be deployed or not, can be allowed or not, at what stage when you go for taking the registration and when the contractor goes for license. When the license is issued subject to certain conditions. One of them is that they should not be engaged in perennial work. I'm talking about law. In practice, what happens, you know it better. Now, whether it's a perennial nature or not, after considering all these points, the government is empowered, the appropriate government is empowered to come out with a notification abolishing that particular job in that particular industry or group of industries for engaging contract labor. So which means in that particular job you cannot engage contract labor at all. Now in the central government there are many notifications like that. In many states you have got many notifications. You will be asking, what about Tamil Nadu government? If you look at the Tamil Nadu government notifications, it is nil. It is nil. The only notification they brought out was in 1976 is that in production, in the factories and other establishment, you cannot, the job of scavenging and sweeping, you cannot engage contract labor. But that notification was challenged by BHEL and one more, L&T McNeil. And the High Court and also Supreme Court for subsequently, it struck down that notification. Since then, there is no notification in Tamil Nadu prohibiting or abolishing any job for engagement of contract labor. Now, but nevertheless, the position of law doesn't change. Position of law stays. Because before you engage any contract labor abolition, the government has to give a sufficient notification to the industry and seek for explanation and then consider it, then abolish it, which was not done in those cases. Therefore, on the technical ground, it was struck down. So this is what happens. So therefore, today, technically, you can engage contract labor virtually in every job, which all the industries are happily doing it. Okay. Now, well, many sections will deal with. Then also the contractor has to provide, or if in the absence of contractor, if he doesn't provide, you have to provide canteen, restroom, and other facility, first aid facility, everything you have to do it. I mean, like the regular workman, you have to provide all the basic facilities, welfare facilities as given in the Factories Act. If you remember well, in Factories Act, the worker includes contract worker also. So therefore, it is being reiterated here. That's the point. Okay. Obligation of principal employer. I told you that he has to have a contractor, he must have a license, he should have the registration. So now, what are the do's and don'ts and all this of welfare facilities? Payment of wages, I sufficiently talked about it. You have to pay the wages in that. Actually, this one more thing is, the wages have to be paid to the contract workman in the presence of a representative of the employer. Principal employer. That's principal employer. There is a prescribed format. There is a register of wages where the wages are given, the breakup in the register of wages. At the end of the thing, he has to sign it having received the money. At the end of the page, the representative of the contractor, so not contractor, the principal employer, what language to be used is that he has witnessed the thing and has been done as per the provision of the Act, and he has to sign it and seal it, which is more often than not done. But what happens is, the backup papers are kept by the principal employer, like the attendance, everything, and everything is there. And it is also inspected by the inspector of factories in this case. Sorry?
What out here, after option establishment time, it says that payment should be made within 5th of the subsequent month. After option establishment time.
Sorry? Sorry, I'm not able to catch up.
As per option, as per option establishment time, it says that the wages should be made within 5th of the subsequent wage period. And the Payment of Wages Act says 7,000 is the bigger wage pay. What shall I pay for the contract employee?
What about the contract employee?
Yes.
He has to be paid at least on 7th.
At least on 7. But Shops and Establishment states that it's about person employee.
See,
Whether person employee equals contract employee.
see, Shop and Establishment Act doesn't speak of employee. It doesn't speak of worker. The word used is person employee.
Yes, exactly.
So it includes everybody, but it doesn't speak of contract labor there. But the Shop and Establishment Act will include, the Contract Labor Act will include Shop and Establishment Act also, because there is a notification for that. There is a notification for that. Okay, for example, if you take a cinema theatre, he's coming under Shop and Establishment Act.
Yes.
There will be a contractor. He has to pay on 7th. So therefore that takes over. But the general thing is 1,000 employees, below 1,000 employees 7th, above 1,000 employees 10th. That's what we found. And it's accepted by the inspecting authority.
Thank you.
Yes, sir.
Security guards service, is it coming covered under the contract?
I was about to come to that. See, the fallacy in the whole of the matter is like this. It says perennial nature. Now, security guard is a perennial job, right? And to that extent, the central government has brought out a law in 2005 called Private Security Regulation Act, which talks about engagement of security, what are the qualifications, what is the standard, how they can be employed, and so on and so on. If it is to be abolished under perennial nature, then how the hell they can bring out a 2005 Act? So, but what happens is, it is allowed, it has not been abolished. Private security in any establishment, that job has not been abolished by any state. Therefore, you can engage. Right.
The registration is required?
Yeah, if you are employing 20 or more workmen, registration is required.
Nobody does. Why not?
No, we all do it. In our, you can check in our registration certificate of the companies.
No.
I'm talking about all the group companies.
What I mean is, there is an principal employer. Their only contract employment is the service, the security. In that case, whether they
No,
have
if they are going to have say very few people, they may not. But if there are about certain, 20 or more, certainly. And this 20 or more, in the context is not only of one contractor, all the contractors put together, all the contract labor put together of different contracts. So if they are having only service contract, there are only 17 fellows or 15 fellows, they would not have gone for registration.
so that 20 civil is only the contract.
Yeah, not the regular work. Oh, sorry, I gave an impression of regular workman, is it? Sorry, I stand corrected.
Regular plus contract.
No, it is only the contract. Well, okay. Now I will straight away come to what are the things that we need to be quite prepared is there has to be a proper contract between the employer and the contractor. It has to follow all the norms of a valid contract. There should be proper consideration has to be spelled out. And most importantly, the job, there are two types of contract which we say, job contract and labor contract. More often than not, every damn job contract is a labor contract in camouflage. Let us accept it. But while doing so, at least you quantify the job in the contract, the eyes of law. That's very important. That's what I said there. Number one. Number two is, the consideration has to be spelled out very clearly. Don't be writing, I have advised all the group companies, don't be writing, I will engage 250 people, I will engage 126 people in 3 shifts of 40. Don't write any of this. You state the quantified job, what is the consideration, and the consideration, how you arrive at is your own problem. Okay, which has to follow many other norms, including minimum wages, or you may pay more than minimum wage also, and so on and so forth. And therefore, the contract is the very, very important thing. And most importantly, the contract has to state that the job being entrusted to the contractor, first of all, you have to say whether the contractor is competent to do it or not. You have to have some kind of a preamble for that. And the contract, the job shall be done under the contractor's supervision and control. Very important. If the and to that extent you have to prove it. Tomorrow there were to be an inspection. You have to prove it that there is a supervisor available on the shop floor supervising either their work or everything. Now, what is the supervision and control? Supervision and control means a span of control, number one. Number two, disciplinary control, administrative control. All these things shall be properly spelled out, so that the job shall be done in a competent manner under the supervision and control of the contractor. That's very, very important. More often than not, everything which can amount to, you just look back. If I have to make a labor contract, how will you do it? You will mention everything about the labor there. Remove everything, that's my point. One. Two, the bills which he is giving to you. He has to give a service bill, not labor charges bill. I know one particular case, you may not have noticed long back. The bill comes, what you call bold letters at the top, the black, this thing, labor charges, or labor bill, something like that. And the company has been happily clearing it also. Well, it's certainly a labor contract. But the thing is, there is a supervisor there who is also doing the supervision. Over and above that, your man is also doing supervision. So where is the question of you are claiming yourself to be a direct employer for him? Still you are a principal employer only. So therefore, care is to be taken how the bill is raised, invoice is raised by the contractor, service provider to you, and how you make the payment. Many times what we do is the contract labor will be punching the same punch of your regular employees. Keep them separate. For food you may provide the same food. Don't discriminate. But keep everything separate. So to that extent try to treat them differently and to do that. So, for example, you may say, even the Supreme Court has said that in a particular case of Calcutta Electricity Supply Corporation case, there is a contract labor doing the job. I go and inspect it. Just because you go and inspect your own product but done by a contract labor or under a contract, it doesn't mean you become suo motu an employer. You don't become de facto employer at all. Because he says everything that is done under the gaze of the principal for the purpose of ensuring quality cannot be attributed to be a criterion to decide whether a particular employee is whether a particular employee is a direct employee or a contractor. So these are the precautions that we need to take, do that. And therefore, possibly you have to devise a method by which you look for these things to see that the, before you put down anything in writing to them, to guide the, to make the people understand that they are not, whether they are on the right track or not. See, today the contract labor, see, like the Joint Secretary of the Ministry of Labour, he told in publicly with us, Joint Secretary, who is the level of the Secretary here, he said contract labor has come to stay. You cannot escape it because the biggest employer of the contract labor today is the government, not you. So therefore, you have to take all the precautions for the this one. It is only in the government sector the contract labor are regularized without any problem, but of course they also have a problem because, but the point is it is arising out of any political issue about which I don't want to comment here. But the point is when it goes before the court of law, the court says, are they sanction posts? For them there is something called sanction post. If they are not sanctioned posts, and if somebody is coming through the back door and seeking for regularization or permanent employment, it cannot be allowed. It is against the public policy. Very simple. It says that.
Sir,
Yes, sir.
you were differentiating between labor and job. What is the significance, sir?
Right. Okay. See, labor contract is the contract where the labor is used for, say, like, you want to build a wall in your house. You say that, I'll buy all the material, you have to come and do the work, therefore I'll pay for your wages only. There is a labor contract. A job contract is, somebody comes to you, like your urban tree comes to you, I'll repair this and I will charge this. That is a job contract. I mean, to put it in the term that you will understand. In the same way, the employee, here also it happens that a job is given to the employer, to the contractor. You give me so many pieces of work, so many pieces of the product, I'll pay you so much. There is a job contract, right? Depending on the number of pieces you pay. But how you arrive at the costing is a different thing altogether. Let us not go into that. But the labor contract is, daily you give me 10 people for sweeping the floor, I'll pay you so much. But my point is,
what is the advantage? I mean, what is we are hit when if you miss do it?
see, under this law, all job contract, labor contracts are the same.
Yeah.
Right. Only in the code, in the code that will be coming now, it says a job contract is also a contract. A labor contract is also a contract. It specifically says labor contract is also a contract. So therefore, virtually it only reiterates what is there in the law today. Everything is a contract. Okay. But what happens is, when you go before many times you will be told by the employer, sir, that is job contract, sir. It is not a labor contract. He will try to divert you. But you have to see how the job contract has been treated, whether it looks like a labor-oriented one. The point is, you should only, if a contract should not be a sham contract, only when you engage a contractor to do your job under his supervision and control, then you don't have any liability on that. You don't have a liability. For that, you need to have appropriate documentation. Documentation is the most important thing on the contract level, which will speak for itself.
So labor contract can be easily.
For example,
direct.
Absolutely. It straight away relates. He is the employer. See, after all, what is the employment? There is an employment relation between the employer and employee. Then employment relation has to be established, right? Where will get established? If it's a labor contract, it will get straight away established. This fellow is only an intermediary. So the court will say, I am lifting the veil. I am lifting the veil and piercing it through to find out whether there is a fact. What is the fact? Whether he is your employee or not. If the fact is that you are an employee, then you are already employer. You better regularize it. He can come to that. Okay. So with the note of caution, I am winding up. I think there are no more doubts. Even if you have doubts, you will suppress it, I know. It's okay. All said in a lighter way. I am very happy that I could come over and share with a little of my knowledge with you as much as possible. Thanks to SICC and Mahesh for having given me this opportunity. Thank you. You got a question? Okay.
With your permission,
No.
questions on two unrelated topics. First one is on the on the Maternity Benefit Act. Is it okay for an office to say, no, I'm not providing a creche, but I will go ahead and reimburse the particular specific group a reasonable amount, let's say about 5,000 rupees or 7,000 rupees from the time they have a child till the time when, let's say, the child is about 5 years old or something?
I'll reply straight away. The law doesn't provide for it. You know why? Creche is a methodology for the woman employee to take care of the child while being in work. Says because you have to allow the person to go for every 4 hours to nurse the child, to provide XYZ service to the child, which will be otherwise under the care of the creche undertakers, right? So therefore, it also says that it has to be within some 2 kilometers radius from the place of work. So therefore, it doesn't say. But if there is a crash within 2 kilometers or whatever, you can tie up and contractually you can get it done. It need not be your run. It can be their run. You understand? But it doesn't absolve you by payment of X amount to her. See, you want to plug the mouth of, shut the mouth of the lady to say that I give you money, I can't provide it, because it's a genuine thing. But the point is, the inspector will come and say, where is the crash? Show me the crash. So that's where you get caught. So they will say it is not provided in the law. So that's the problem that we are normally putting in industries. Second question, sir?
Second question is with respect to the occupier of the factory. Is it okay for, given that every
The director has to be the occupier, sir.
Correct. Every director is deemed to be an occupier if we don't go and declare.
Every director not deemed to be occupier. A director so designated and declared becomes the occupier.
Other than the independent director.
Independent cannot be done. There is a case law also.
Can a non-resident director be designated, or is there a requirement that the person has to be in India for a specific number of
No,
days?
it doesn't say so. A non-resident director also can be director, because after he does it through his people, he becomes ultimately, what does it say? A person who has got overall control over the ultimate control over the affairs of the company. This is the T word. Ultimate control over that. So, is the non-resident director also becomes a problem? Yeah, there is a problem with the multinationals. Yes, but this was fought over with the ministry to remove this, to give certain exemption to certain. They are not accepted it.
Can we extend that to the manager of the factory?
No, manager of the factory in any case he is liable. In case. So what you do is you create one director, put him there, and say declare it that he is ultimate control. Then prosecution lies with him. Non-resident stays abroad. That's all. I mean, that's the only way of beating it down. There's no other. Okay. Thank you.
Sir, just a quick, sorry. The gratuity insurance, is it to come?
Yeah, correct. Good point. I wanted to tell you this. I was rushing through like a cyclone. I just missed it. Section 4A, capital A of the Act says there's a compulsory insurance has to be done through an appropriate method, which is a trust and all that, which is also prescribed LIC. It talks about, or any other insurance product. Now that section was inserted, I don't remember the year, but then not enforced.
Not notified.
There are many sections in the law which have not been enforced through an appropriate notification. This one. Yet another major important notification which has not been, amendment has not been notified is the definition of industry under Industrial Disputes Act.
This section has been notified in Telangana and Karnataka now.
In Tamil Nadu has not been notified.
Both Telangana, old Andhra, which is Telangana and Andhra now, and Karnataka recently it has been.
It is not notified. So therefore, but many employers who are deserving employers, they go for this thing. So it is absorbed.
Especially it's a large.
And you provide for 4.81% of the total wages. I mean the reckonable wages. With basic plus DA. Clarify?
One final
Yes, sir.
question. Minimum wages, is it only basic and DA or other also?
No, as per law. Yeah, quickly I'll tell you, I'll finish now. Basic DA and HRA as per law. But some places they provide for all the both three together. In case of Tamil Nadu, they have notified only as basic plus DA. And in some Kerala, it is basic. In some scheduled employment, basic DA, HRA, CCA. Is also there.
Thank you, sir.
Okay.
Thank you.
Thank you.
Sorry, just a quick thanks to sir, please.
Thank you, we for sure now. Just one more minute.
Yes.
So, when he was just finishing, he said I went like a cyclone through my slides. He's really, you actually poured down knowledge on all of us, and I think 2 hours is not sufficient to cover this. It's fairly comprehensive, sir, but I think that we need a lot more of sharing of knowledge and experience from you. Hopefully, we will be able to invite you for full day session.
So you can say Godarum.
Yeah, the next episode will be coming in soon as a full day session. We hope you'll
Maybe
be.
you can think about more competent people to come also.
No, we
can
think
have a
that.
different
Definitely.
Yeah, we will call somebody else along with you to share the space with you. I think that would work out well. We'll definitely organize one. So thank you so much for sharing. It was actually a deluge of information here, and our perspective itself has changed with reference to labor laws. Thank you so much, sir, for coming. I think the updation for everybody here has been extremely high. So thank you, sir. Thank you very much. Thanks, Mahesh, for referring sir to us, and because of sir's deluge of information, Mahesh has been sitting there silently.
I did warn Revati even in the beginning that there will be enough material.
Yes.
And just thought I will keep it more as a buffer or a filler in case the session gets over. So that is.
So
I should thank Srinageshwar for all the time.
You escaped.
So probably we'll have Mahesh also speaking with us in the next session. Thank you very much. Thank you everyone for your listening and making it a very interactive session. Thanks a lot.
I thank for your forbearance with me.
No forbearance, sir.